One. Yes.
Please, my lord. Worship, I beg to mention item number 14. 1 4.
1 4.
Yes. Worship, this is a joint prayer. If the matter may kindly be listed after 3 weeks, Lordship, we have some difficulty today.
Okay, that's okay. But he's in custody or bail? The appellant is in custody or bail?
Custody.
He's in custody.
Yes.
Oh, it's 18 matter. So I think it will be better to do it. If not today, then soon after. Isn't it? You want it after 3 weeks?
Okay, now, my lord.
After 3 weeks, you want it? Learned counsel for the appellant with the consent of the sir, you're for the informant.
My lord,
You're for the
I'm for the appellant, my lord.
you're for the appellant.
Appellant.
You're for the informant. You're for the state.
State.
Sorry, state. You're for the state. Learned additional PP or
EP, Lordship.
Learned public prosecutor for the state submits that with the consent of the learned counsel for the appellant, who is also present. He's praying for listing the matter after 3 weeks. Full stop. The prayer is allowed. However, as the he's in what is the provision, penal provision? He's
POCSO, under POCSO.
POCSO, how many years?
10 years.
10 years, but he's already in custody for 7 years. So it'll be better to do it on the next day. So can it be a little earlier than 3 weeks? Huh?
My lord, then
You
2 weeks, my lord.
Huh?
2 weeks, 2 weeks.
list the matter after 2 weeks. The learned counsels on both the sides are requested to conduct a hearing on the next date, as the matter is an old pending one. The matter pertains to 2018 is already in 7 years is spent, right? So we should do it. Please do it on the next day, right?
Like,
Much,
Lordship.
my lord.
Lordship, I also beg to mention item number 8, Lordship. Lordship, here on for respondent number.
Item number 8.
Yes, Lordship, I'm for respondent number 4. Lordship, here. Now, the case of the petitioner has already been approved both by PNAR and Finance, and the matter is to be placed before.
It's in process.
Yes,
it's in
MRC. Yes,
MRC.
yes.
You're for the petition?
Yes, Your Lordship.
So can you grant 4 weeks time?
4 weeks time.
Yeah.
That's okay for you.
No objection, Your Lordship.
Your good name, please, madam.
Sigmo.
Learned counsel for the petition. And learned counsel appearing for respond number?
4.
Respond number 4. It is submitted that the can I recall that the process of compliance
Yes.
with the order in question is in process and has also progressed. And in this context, praise for listing the matter after 4 weeks. The learned counsel for the petitioner fairly submits that she has no objection. Full stop. List the matter after 4 weeks.
Yes, Your Lordship.
And a date to be fixed by the registry. Yes.
But please, my lord.
Yeah.
Lordship, I beg to mention item 10.
Till 10.
Item 10.
You are for the respond.
I'm for respondent number 1.
I see.
There are other 5 more respondents, your lordship. Respondent,
Total 6 respondents.
yes, there are 6 respondents in total. And for the other 5 respondents, I'm not representing them, my lord.
Okay.
I think notice upon them is still awaited.
Can I see
Under
the files? What is your take? You've taken steps, right?
Yes, my
Steps have
lord.
been taken.
Yes, my lord.
Any
And my
order?
lord, on the last occasion, the respondent number 2, this is the Commissioner and Secretary, the PNAR department.
Mhm.
They have issued a communication before this court,
Mhm.
but they were not represented by counsel.
I see.
So they have received the copies,
Mhm.
but they are refusing to appear, my lord.
You are only appearing for 1.
Yeah, I'm only appearing for
2
one.
to 5. 2 to 5 are there. Yeah, this is reflected in the last order also.
Yes, my lord. His personal attendance may be called, my lord, as to why he's not complying with the
Received a letter
order of
from
this honorable court.
PNR. Written by the Deputy Secretary. There's an indication that there's a mention that perhaps the notice upon respond number 2 is not complete because it was the channel was not proper. It went, it should have been correspondence ought to have been made to the counsel for the respondents.
Correct.
So what do you suggest? No point taking fresh steps. No,
No, my lord. They have already received notice.
Already.
They should have contacted their counsel, the department.
Lordship, in that event, if I may be allowed to make a short submission on this.
Yeah, sure.
Your Lordship, as far as the regularization as per the Office Memorandum 73, 2015 is concerned, the respondent department, they are supposed to actually take steps and then move it on to the PNR department who's met the respondent number 2 here.
The concerned department.
Yes. The concerned department is to take steps and then after taking steps, they are supposed to send it to the PNR department for approval and then to finance. Now, Your Lordship, whether that steps has been taken or not can be only explained by the other respondents. That is the concerned department, Your Lordship.
True.
So at least if sometimes can be granted so that at least the department can come and appear, Your Lordship, and explain it to this Honorable Court as to what steps has been taken, my Lord.
He has prayed for personal appearance, but we can give a short time. And then if nothing happens, then maybe we can,
Yes.
seek their assistance personally.
Correct.
Not way up, something.
Yes.
I don't believe in that.
Correct.
Calling someone and being harsh, not that. If we are unable to connect, then we'll request their presence and then we'll seek their help. We'll hear from them directly.
Lordship.
But sometime, I think you're right. For the moment, some time can be given.
Yes, ma'am.
Maybe 2 weeks.
Fine, madam.
3 weeks, Your Lordship.
3 weeks.
3 weeks.
Third, counsel appearing for the respond number 1. However, none appears so far with regard. On behalf of respond number 2 to 5. Peruse the previous order dated 24/3/2026. Full stop. In this context, the learned counsel for the petitioner submits that steps have already been taken, and as per his information, they have also received the same.
Yes, my lord. They have communicated before this.
Okay. And the steps upon respond number 2 to 5 have already been taken, and they have also received the same. And the same is also reflected in the aforesaid order dated 24/3/2026. The learned counsel for respond number 1 submits that perhaps some time can be given to see as to whether the respond number 2 to 5 appear and make their position clear regarding the issue of compliance of the concerned order. This is the matter after 3 weeks. We can fix a date. It will help them also because they will also, if they come in touch, then if they connect, then they will know the specific date. You can fix a date after 3 weeks. 21. 12th May or something.
14, Your Lordship.
14 May.
Yes, 14 May.
14/5. Okay. Any other mention? 14/5.
Obliged, my lord.
I'm deeply obliged.
May it please, my lord.
Yes.
My lord, as regards to item number 3, my lord, I am for the petitioner. My senior colleague, Mr. KL, is there for the respondents, my lord. My lord,
Okay.
the connected issue is pending before Honorable Supreme Court, my lord. And orders dated 12/3/26 and 5/2/26 reveals that, my lord.
Okay. So you're for the petitioner.
I am for the petitioner.
Chief, I am appearing for the respondents also.
So sure, both the learned counsels suggest that we adjourn the matter today.
Yes, Lordship. Next date is fixed on 29/4 before Supreme Court, Lordship.
The learned counsel for the petitioner and Mr. S.C. Kyle appearing for the respondent or for the respondents / union appearing through the online mode, submit that the matter is pending before the Honorable Supreme Court. And next date is fixed on
29/4.
29/4/2026.
Not sir.
And in this context, praise that the matter may be adjourned today and list after some time. The prayer is
There is an,
list the
there's an
matter.
interim order.
Interim order shall stand extended till the next date of listing. List the matter after 4 weeks.
Lordship, but if it's possible, Lordship, date may be fixed in the first week of May, Lordship.
Second week.
Can it be on second week, my lord?
I think second week would be better if you say,
Lordship.
like say somewhere in the middle of second week, 8th of May. How about 8th of May?
Lordship.
8/5.
Lordship.
8/5.
Lordship.
Okay.
Lordship.
Obliged. Highly obliged.
Yes, this man.
May it please your lordship, I beg to mention item number 12 and 13, your lordship.
Item
12 and 13, your lordship. The service report for respondent number 4 and 5 is still awaited, your lordship. If the matter can come up after 3 weeks, your lordship.
Learned Counsel, your good name, please.
Kim Piana.
Yeah, Kim Pien. Learned Counsel for the applicant appellant. Within bracket insurance company submits that service report upon respondent number 4 and 5
Yes, your
are
lordship.
still awaited, and therefore perhaps the matter may be posted after
3 weeks.
after 3 weeks. Mr. Prayer is allowed. List the matter after 3 weeks on a date to be fixed by registry.
Yes. Obliged, your lordship.
Yes.
Please, Your Lordship, I beg to mention item number 16 on behalf of my colleague, Miss Inauli, Your Lordship. If this matter can come up after 2 weeks, Your Lordship, she is indisposed.
Yes. This submitted on behalf of the learned leading counsel for the petitioner that the matter may be listed after 2 weeks.
2 weeks, Your
2 weeks, as the said learned counsel is indisposed at the moment. Prayer is allowed. This is the matter after 2 weeks on a date to be fixed by registry. Kindly inform the other side. You're for the other side.
Yes.
Much obliged.
Obliged.
Your Lordship,
Yes. Which matter?
your Lordship, I would like, Your Lordship, can I mention the item number 4, 5, 6, and 7?
Wait, just a minute. I'll come to you. Just a minute. Come to you. I can hear you. I'll come to you. Yes.
4, 5, 6, and 7.
5, 6, and 7.
My senior is in bereavement, so if the matter be listed after 2 weeks.
You're mentioning the same matters. Or kindly unmute yourself. I think you got muted. He got muted. Is he making the same mention?
Yes,
online?
Lordship.
Okay. Then there's no problem. 4 is not connected. 4.
It's connected
4, 5, 6,
and 7.
and 7. All 4. Okay. But there is an interim order, so I will adjourn it. But when do you want it?
The 3 weeks.
Anyone appearing for the ED? No, I cannot hear you. You're muted.
Your Lordship,
Now I can hear you.
Your Lordship, I'm appearing for the ED, Your Lordship.
So you're appearing for the ED.
Yes,
Your-
Your Lordship.
Appearing for the.
And
No, she's here. Yes.
yes, your SPP, Your Lordship, Special Public Prosecutor for ED.
What is your submission on behalf of the department?
Your Lordship, we need 3 weeks time to file reply, Your Lordship.
So you also want something? No issues then. Okay, no problem.
There's an interim.
Yes, I know. I've seen the file a little bit. Learned counsel for the petitioner. 6th for posting the matter after 3 weeks. The learned counsel, your good name, please, sir. What is your good name?
YP Gupta.
Appearing online.
YP Gupta.
YP Gupta, learned special PP.
Yes, Your Lordship.
Enforcement Directorate, appearing online, submits that the department also seeks 3 weeks time to file a written objection. First, the the prayer is allowed, list the matter after 3 weeks. Okay, after 3 weeks. You want a date, the interim order passed by order dated so and so stands extended till the next of the date of listing. List the matter after 3 weeks on a date to be fixed by registry. 4, 5, 6, and 7.
Yes,
Right?
Your Lordship. Which
O-
apply?
Oblige your lordship. Oblige your lordship.
I also beg to mention item number 15.
That's okay, madam. You're for the respondent too.
I'm for the petitioner, my lord.
You're for the appellant.
Yes, appellant, my lord.
Appellant. You're for the
Respondent.
respondent for prosecution.
Respondent number
Private.
yes, amicus curiae.
POCSO matter.
Yes, Oxo
POCSO
matter, my lord.
matter. My only concern is that he's in custody.
No, he's out, my lord.
He's out. He's
Yes,
on
my
bail.
lord. Yes, on bail. As for the consensus prayer, if this matter can be fixed on 14th May.
Learned counsel for respondent number 2.
Yes,
Your good name
Yukakokla.
for 6 praise for listing the matter after 3 weeks.
No, on 14th May, my lord, on the consensus prayer.
On 14th of May.
Yes.
6 for adjourning the matter today and fixing it on 14th of May. The learned counsel for the appellant also supports the said prayer and 6 the same date. List the matter in the hearing column on 14/5,
Yes, my lord.
2026.
Oblige, my lord.
May I please, Your Lordship? I beg to mention item number 2.
Item 2.
Item 2, yes, Your Lordship. I'm appearing on behalf of the lead counsel for respondent 1 and 2.
Respondent number 1 and 2.
2, yes.
Can I have?
Your Lordship, we've been informed that the matter is under consideration. Therefore, if Your Honor, if Your Lordship may kindly grant us 3 weeks' time.
Petitioner, anyone for the petitioner?
Lordship, for the respondent number 3, the accountant general.
Okay, you're for the petitioner, madam?
Yes, my lord.
Learned counsel for the petitioner. And you are, madam, representing respondent
Respondent 1 and 2
number
on behalf of the lead counsel.
respondent number 1 and 2. And learned counsel
For respondent number 3, my lord.
for number 3. 1 and 2 and 3. So all are there. Learned counsel for respondent number 1 and 2. 6 an adjournment of the matter today. And further submits that the order in question passed by this court, the compliance of the order passed by this court is an active consideration, and for the said purpose, some time is necessary. Right? Also, anything from your side? No.
My lord, we are awaiting their instructions.
Okay. Take the instructions. List the matter after
3 weeks, Your Lordship.
3 weeks. List the matter after 3 weeks on a date to be fixed by registry.
My lord. Lordship.
Much obliged.
Prohibition, item number 1.
May I please, Your Honor, as per the direction given by this honorable court, we have deposited the 50% to the registry of this court.
Okay. Stay order has not yet been passed. Stay order
Not yet passed, Lordship.
not yet passed. Right?
Not yet. Lordship.
You are for the appeal.
Respondent number 8, my lord.
Respondent number 8.
I am appearing on behalf of respondent number 1 to 7.
1 to 7 and 8. For formats, owner of the legitimacy. So you'd like to withdraw the amount? Would you like to withdraw the amount?
It's up to the Lordship. If you allow, we can withdraw.
Yeah, they will submit a bond or something and then withdraw, isn't it?
Yes, Lordship.
As per the usual procedure.
Yes, Lordship.
Usual procedure. Ms. Land Counsel
Madokiki.
appearing on behalf of the appellant insurance company. Appeal has been admitted, right? Must have
Yes,
been
Your Lordship.
Not yet admitted.
Lordship, admitted.
Yes. This heard so and so for learned counsel for the appellant. The appeal was admitted on 2/2026. It is submitted on behalf of the appellant insurance company that 50% of the awarded amount has already been deposited before the registry of this court.
Yes, Your Lordship.
Learned counsel appears online on behalf of the respondent number 1 to 5, right? 1 to 7. 1 to 7. In bracket, the claimants and learned counsel appears for the respondent number 8. Within bracket, owner of the vehicle. Has the TCR come?
No.
The original, the TCR in original as called for has already been received. You can file an you can file an application. I can give an order now also, but you can if it is up to you. You are at liberty to file a separate application also, seeking to receive the amount. Would you like to file an application? And sorry, I should be addressing you. Yes.
It is up to Your Lordship.
Would you like to file a separate application for the same?
It's all right, Lordship. If you can give a direction, we can withdraw.
In view of the deposit of 50% of the awarded amount by the appellant insurance company, till the disposal of this appeal, the impugned judgment and order, judgment and award dated 28/2/2025, passed by a learned member MACT Dimapur in MAC case number 40 of 2012, shall remain state. Full stop. The respondent number 1 to 7 are hereby allowed to withdraw the 50% amount deposited by the appellant insurance company before the registry, subject to proper identification. And indemnity bond, you'd like to give? Indemnity bond and any other necessary formalities. So now matter is almost ready for hearing also, actually.
Lordship.
We'll list it after how many weeks?
3 weeks.
3?
After 3 weeks.
3 weeks.
Yes.
3 weeks. Your colleague
Yes.
here.
Lordship, yes.
This is the matter after 3 weeks on a date to be fixed by registry. You can dispose it on 2025.
Much
You
obliged.
can receive
All right, Lordship.
amount.
For this item number 9.
Lordship, I'm for respond number 1 to 5. On the last occasion, I was directed
Just a minute. 9, adjourn 8 to 8. I think mentioned. Was 9 mentioned? No. 8 is mentioned. By mistake, I think that was. Sorry, please. What are you saying?
Lordship, I'm from respond number 1 to 5, Lordship. As per the last order, I was asked to get instructions regarding the details of the legal representative for respond number 1. Respond number 1 has expired. So I may need some more time, Your Lordship, to get the details, Lordship.
You are for the petition.
Yes, Your Lordship.
You are for 1 to
1 to 5, Lordship.
1 to 5. Anyone for 6? District Bar Association. And pro forma respondent is also there. What about service? It's complete. Let me check.
6 is not complete.
Service of notice. Service of notice.
Yes, Lordship.
Is it
Completed,
complete?
yes,
Is it complete? government advocate has appeared for respondent number 7. Pro forma respondent is so censored. Has the record been received? Learned counsel for the petition. Learned counsel appearing for respondent number 1 to 5. Stop. As reflected in the previous order dated 14/10/2025, learned government advocate Ms. Ina Holi had appeared for respondent number 7, within bracket pro forma respondent. So that leaves us with respondent number 6, return unserved with the remark that no such person upon 6 notice upon 6 has been come back has returned with the remark that no such person exists in the same location. Can you attempt a dusty service? Because he's an advocate of Dimapur Bar Association, the District Bar Association, so should be.
Lordship, the steps have been taken by speed post.
Speed post.
Yeah.
No, it, as per the office note, full stop, please.
We'll try again.
Write that also.
We'll try again.
Huh?
Dusty service, true.
Yes, sir. Respondent, as per office note dated 12/4/2026. Sorry, 6/4/2026. 6/4. Serial number is 12. 6/4/2026. Service upon respondent number 6 was returned with the remark that no such person existed in the said address. In this context, the learned counsel for the petitioner submits that they may be allowed to resort to dusty service. Prayer is allowed. The petitioner shall text fresh steps upon respondent number 6 by dusty service and submit the compliance affidavit. Right? This is the matter after 3 weeks.
Lordship, there's an interim.
Interim order. The interim order passed by order dated 14/10/2025 stands extended till the next date of list.
Much obliged.
The original record has been received or scanned record? The scanned TCR as called for has already been received. We'll just write it.
Orders, item number 11.
10 is mentioned in screen.
Lordship, here I have instruction to appear on behalf of opposite party 1. And on the last petition, I've prayed to file my power. However, the opposite party, due to some difficulties, is not able to come to the pen signature. So I may be allowed another 2 weeks time. 3 weeks to file my power.
Only 1 and 2, right? You'll be appearing for 1.
1.
And the accountant general, the pro forma opposite party.
Yes, your lordship.
You are for?
I'm for the appellant, for the petitioner.
Petitions.
Yes.
Applicants. Okay. Third, learned counsel for the applicant. Learned counsel submits that he has been instructed to appear on behalf of respondent number 1. However, the said litigant could not come today to sign the sign the wakalatnama, and he seeks some time for the same.
No.
The prayer is allowed. None appears for respondent number 2 within bracket pro forma respond. So probably 1. They have a standing counsel. Accountant general has a standing counsel.
Yes, your
You
lordship.
can just convey it to her.
Oblige.
List of
Trucks.
tweaks.
Yes. Obliged, your lordship.
Supplemental justice for hearing, I think, 17.
All done. It's all done.
Insecure.
Yes.
Please, Your Lordship. Your Lordship, so that we have a point of reference and the matter is not very, doesn't take much time. There's already a decision of this honorable court, a judgment by Justice Devashish Barua about the powers of the Lok Ayukta. Can I place that? Lordship, this is about a criminal case. But in dealing with the criminal case,
Just one. Notes. Something to- Notebook. Yeah,
in dealing with the criminal case, the powers of the Lok Ayukta was also discussed.
yes.
Now we can go straight to paragraph 8.
Of the judgment.
Yes, Your Lordship, at page 7. The first few paragraphs are the facts about the criminal case, the registration of the criminal case, beginning from when its previous avatar as the Vigilance Commission,
Ah, yeah.
and then its transference
Yes.
to the Lok Ayukta.
Now,
Now,
should we read this?
should we read the entire judgment, Your Lordship?
I can have Peter as
Very well, Your Lordship.
in the meantime.
And we can start with paragraph 3 then. Or from the beginning.
No, not from the beginning.
Okay, from paragraph 8 then.
I'm on 8.
Yes. Be that as it may, in the meantime, there have been certain statutory developments in as much as the Nagaland Lok Ayukta Act of 2017, which is Act 1 of 2018, was enacted. In terms with Section 36 of the Act of 2018, the resolution of the Nagaland Legislative Assembly constituting the State Vigilance Commission should repeal from the date of an appointment of the Lok Ayukta. In terms of subsection 2 of Section 36 of the Act of 2018, it was stipulated that notwithstanding such repeal, any act or thing done under the said resolution shall be made to have been done under the Act of 2018. Subsection 3 of Section 36 has a vital significance for which the same is reproduced hereunder. All inquiries and investigations and other disciplinary proceedings pending before the Nagaland State Vigilance Commission, which have not been disposed of, shall stand transferred to and be continued by Lok Ayukta as if they were commenced before him under this Act. From a perusal of the above quoted Section 3 of Section 36 of the Act of 2018, it would reveal that all inquiries and investigation or other disciplinary proceedings pending before the Vigilance Commission and which has not been disposed of shall stand transferred to and be continued by the Lok Ayukta as if they were commenced before him in the Act of 2018. In view of the above, the investigation being RC 10 of 2017, which was initiated under the aegis of the Vigilance Commission, which was pending investigation at that relevant point of time, should transferred to be continued by the Lok Ayukta, as if they were commenced before him under the provisions of the Act of 2018. The consequential effect of transferring the said investigation within the fold of the Lok Ayukta, that too under the provisions of the Act of 2018, is that the said investigation has to be carried out in terms of the Act of 2018, and any further steps which were required to be taken had to be taken in accordance with the Act of 2018. At this stage, the court finds it relevant to take note of Section 15, 16, and 25 of the Act of 2018, which would show as to what the Lok Ayukta or the Upalok Ayukta can do in terms of the Act of 2018. A perusal of Section 15 of the Act of 2018 would show that the Lok Ayukta or the Upalok Ayukta, being prima facie satisfied during the course of inquiry or investigation that allegations or grievances against any action is likely to be substantiated, either wholly or partly, may a report in writing recommend to the public functionary concerned to stay the implementation or enforcement of the decision or action complained against, or to take such mandatory or preventive actions, such terms and conditions as may be specified in his report. Section 16 stipulates that the Lok Ayukta or Upalok Ayukta, as the case may, forward an interim report to the competent authority recommending grant of interim relief to the complainant if the Lok Ayukta or the Upalok Ayukta, as the case may be, is satisfied at any stage of preliminary inquiry or investigation that the complainant has sustained injustice or undue hardship in consequence, or any decision or action of a public functionary, and that the grievance complaint thereof should be redressed expeditiously. Further to that, the Lok Ayukta or Upalok Ayukta may, at any stage of the inquiry or investigation, has the power to forward the interim report to the competent authority, recommending to take such action as may be considered necessary by him against the public functionary pending inquiry or investigation. It is relevant that the 3 subclauses to subsection 2 of Section 16 stipulates as to when such interim report is required to be submitted to the competent authority. Those are: 1, to safeguard wastage or damage to public property or public revenue by administrative acts of the public functionary; 2, to prevent further acts of misconduct by public functionary. And 3, to prevent public functionary from secreting the assets earned by him allegedly by corrupt means. 11, it is, however, very pertinent to take note of Section 25 of the Act of 2018, inasmuch as the said provision stipulates as regards the reports of the loco-actor or the upa-loco-actor and what actions are required to be taken by the public functionaries competent authority on the basis of such report. The said Section 25, along with subclause, are quoted herein below. Section 25's reports of the loco-actor or upa-loco-actor. We can go to the section also, Your Lordship. This is important. This is relevant. If after the investigation of any action involving a grievance, the loco-actor or upa-loco-actor, as the case may be, is satisfied that such action has resulted in injustice or undue hardship to the complainant or any other person, the loco-actor or upa-loco-actor shall, by a report in writing, recommend to the competent authority concerned that such injustice or hardship shall be remedied or redressed in such manner and within such time as may be specified in the report, including 1, that any practice on which a decision, recommendation, act, or omission was based should be altered or reviewed, or 2, that any law on which a decision, recommendation, act, or omission was based should be altered or modified, or that reasons should be given for any decision, recommendation, act, or omission, or that any other steps as is legally permissible may be taken. 2, the competent authority to whom a report is sent under subsection 1 shall within 1 month of the expiry of the period specified in the report intimate or cause to be intimated to the loco-actor or upa-loco-actor, as the case may be, the action taken on the report. 3, if, now Your Lordship, the first part, clause 1, is with regard to complaint. So someone who has suffered a wrong, a grievance. Then 3, this is what we're concerned about, Your Lordship. If after investigation of any action involving an allegation, now in this case there's an allegation against me by the private respondent, the loco-actor or the upa-loco-actor, as the case may be, is satisfied that such allegation is substantiated, either wholly or in part, he shall by a report in writing communicate his findings and recommendations. Now, Your Lordship, earlier in respect of a grievance also, it's recommendation. In the case of an allegation also, it is recommendation, nothing more. Nothing more. Along with the relevant documents, materials, and other evidence to the competent authority concerned. 4A, the competent authority in the case of a public functionary other than the Chief Minister or a member of the state legislature shall examine the report forwarded to it under subsection 3 and without any further inquiry take action on the basis of the recommendation and within 90 days from the date of receipt of the report intimate or cause to be intimated to the loco-actor or upa-loco-actor, as the case may be, the action taken or proposed to be taken on the basis of the report. The loco-actor shall send his report in respect of a complaint against the Chief Minister or the member of the state legislature with his recommendation to the governor, who shall take such action as he may deem fit or expedient on the report. That the report of the loco-actor and the order passed by the governor shall be laid on the table of the Legislative Assembly. 5, if the loco-actor or upa-loco-actor, as the case may be, is satisfied with the action taken or proposed to be taken on his recommendation referred to in subsection 1 or subsection 3, he shall close the case on the information to the complainant, if any, the public functionary and the competent authority concerned. But where he is not so satisfied, and if he considers that a case so deserves, he may make a special report upon the case of the governor, upon the case to the governor, and also inform the competent authority concerned and the complainant, if any. So this is after the recommendation. If the loco-actor is not satisfied, he can take further action.
Yes, further action.
Yes. The loco-actor shall present annually a consolidated report on the administration of this act to the governor. On the receipt of a special report under subsection 5 or the annual report under subsection 6, the governor shall cause a copy thereof together with an explanatory memorandum to be laid before the state legislature within 4 months from the date of the receipt of the report by the governor or till the legislature meets next, which is later. If the annual report is not laid in the state legislature within the time provided in subsection 7, the loco-actor shall be free to make the report public in the manner he may choose. 9, the loco-actor or the upa-loco-actor, as the case may be, may at his discretion make available from time to time the substance of cases closed or otherwise disposed of by him, which may appear to be a general, public, academic, or professional interest in such manner and to such persons as he may deem appropriate. 12. From a perusal of the above quoted section 25, and more particularly subsections 1 and 3. So 1 is grievance, 3 is complaint. Allegation would categorically show that the report to be submitted by the loco-actor or the upa-loco-actor after an investigation are recommendatory in nature, and it is on the basis of the said report that the competent authority shall examine the said report and without any further inquiry take action on the basis of the recommendation, and within 90 days from the date of the receipt of the report, intimate or cause to be intimated to the loco-actor or the upa-loco-actor, as the case may be, the actions taken or to be taken on the basis of the report. subclause B and C of subclause 4 of subsection 25 is not relevant for the purpose of the proceedings inasmuch as the matter does not relate to the chief minister or the member of the state legislature. Subsection 5 of section 25 empowers the Lok Ayukta or the Upa Lok Ayukta, as the case may be, to close a case if satisfied with the action taken or proposed to be taken on the recommendation made by the public functionary and the competent authority concerned. However, if the Lok Ayukta or the Upa Lok Ayukta, as the case may be, is not satisfied and considers that a case deserves further actions, the Lok Ayukta or the Upa Lok Ayukta may make a special report of the case to the governor and also inform the competent authority concerned and the complainant. It is, however, relevant to take note of the provisions of the Act of 2018 do not show that the Lok Ayukta or the Upa Lok Ayukta, in terms with the Act of 2018, has the power to act as a police station or officer in charge of the police station. The powers which has been conferred are purely recommendatory in nature. On the basis of the said recommendations, obligations are cast upon the public functionary or competent authority to take appropriate steps. So this is the point you mentioned. Just recommendatory. No power. Yes. No power to take any further action. And if
no, there is some power. I mean, if the action, if the subsequent action he's not satisfied,
yes,
then he can take further action.
Yes. Yes. In terms of subsection 5.
But the crux is that, as per this interpretation, is that it is recommended.
Recommendatory. So if it is be a report and a recommendatory report, the issue in my case, Your Lordship, is an order has been passed.
Okay.
An order has been passed. If it's
order has been passed, directing
penal action against me, coming to finding saying that my appointment was irregular, my appointment was illegal. That is the point. Can you go straight to the finding then of the Lok Ayukta? Can we go to the order of the Lok Ayukta?
Yes. Will be or not?
Page 150.
I have this. I've taken this recast.
Yes, Your Lordship. Yes, Your Lordship.
This is the one.
Yes, Your Lordship.
I'll tag it.
At page 150.
150.
Yes, 150. So can we go straight to the heading itself, Your Lordship? This is order. It is not a recommendation. It is not a report. It is an order. Order dated 8/10/2020.
Right.
May I read, my Lord? Judgment and order. Kindly know the language, Your Lordship. Judgment and order written by the Honorable Upa Lok Ayukta. Srimati Asanglati Iyer, who is the respondent number 4 here, the private respondent, resident of Nahabari, Dimapur, has filed this complaint against Shri Thungdeno Mozui, project director DRDA, Wokha, alleging that Srimati Thungdeno Mozui has fabricated and forged an order regularizing her service and another order extending her service as APO, thereby contradicting one order by another order issued on the same day by the same authority. So this is the basis of the complaint against me. This is it. And this is the complaint, in fact, in a nutshell, Your Lordship. And the point is, Your Lordship, this complaint has not been furnished to me from the very inception. This and the stand taken by the Lok Ayukta is the complaint file is protected from disclosure in terms of the Act of 2018.
Okay. That is what the authority is saying.
Yes, that is what the authority has said.
Okay, now let's.
Now, a preliminary inquiry was ordered to be conducted by the Honorable Lok Ayukta, and accordingly, after completion of the preliminary inquiry, a consolidated report is submitted by the IO Shri Keviko Pusa. Now, even here, Your Lordship may note, this preliminary inquiry was conducted by a police officer. There is a vigilance police station, Your Lordship, under the Lok Ayukta.
Right, next.
The IO established, look at the language, man. The IO established that Srimati Thungdeno Mozui was appointed as Assistant Project Officer on ad hoc basis in the State Rural Development Agency on 29/11/24. Now, this SRDA is an agency. It is not a department under the state, Your Lordship. Again, another point. It is an agency which functions under the state government, but it is not service under the state government.
Okay.
The State Rural Development Agency, hereinafter referred to SRDA, issued an advertisement dated 16/8/85 to fill up 6 posts of APOs of various specialist subjects and 1 post of investigator and 1 post of accountant. In the advertisement, the ad hoc appointees were also made eligible to appear in interview. Shrimati T. Mozui applied for the post of APO General. That's the petitioner. The minutes of the selection board reveals that out of 264 candidates called for interview, 174 candidates appeared in the written test and 25 candidates qualified for oral interview. Out of the 25 candidates, only 24 candidates appeared in the oral interview held on 26/11/85. The following candidates were selected. So APO General 3, APO Agriculture 1, and APO DWCRA 1. In the meantime, the SRDA extended the ad hoc appointment of the following APOs for a period up to 28 to 26 or till regular appointment made through selection board, whichever was earlier. My name is the serial number 2.
Right.
From the 6 APOs whose services were extended, Shrimati Asangla Temjun, the complainant, was appointed as APO on successfully qualifying an interview conducted. 2 APOs were sent back to the parent department. 1 APO was terminated. However, in the case of Ms. Tungdeno Audio APO, her service was further extended as APO veterinary. Next page. Now the point is, Your Lordship, the investigation was conducted by a police officer. All these findings are findings without the participation of the complainant, the petitioner. And these findings of the IO of the case have been taken as gospel truth by the Upa-Lokayukta. We have perused the report of the IO and related requisition files in connection with the case. From the record, it is established that both the complainant and Shrimati T. Mozui were serving as APOs on ad hoc basis under the SRDA, having been appointed during July 1984 and November 1984, respectively. In challenge by the complainant in this case is that Shrimati T. Mozui has produced 2 contradictory orders issued on the same date relating to extension of ad hoc service and regularization, which is here and below reproduced. So the 2 orders. Then the first one is the extension, and at page 153 is the order regularizing her service. And all this is the time when her service was under the SRDA. And at the bottom of the page, the first extension order is prima facie irregular, as service rules jurisprudence is that any ad hoc temporary appointments are over when regularly selected through an interview candidates are appointed against the post held by ad hoc temporary appointees. A letter by the project director SRDA to Shrimati Tungdeno Audio is reproduced herein below to substantiate this point. Now, these are findings. These are perverse findings, if I may say so, Your Lordship. These are findings without any basis in law. Then the next order is a letter directing her to appear for the interview at page 154. Then next page, 155. In the absence of copies of proper notification, we have to go thoroughly through the requisition file pertaining to the recruitment of officers for the agency. We found the copy of the minutes, which is reproduced below. In the copy of the minutes. All these documents examined behind my back, Your Lordship. Then page 156. Page 156. After the recommendation as above mentioned, we found in the requisition file that the appointment orders of the recommended candidates were issued on 13 February 86, separately.
This is on page?
Page 156, at the bottom of the page. After reproduction of the minutes of
the recommendation, as mentioned, we found in the requisition.
We found that the appointment orders of the recommended candidates were issued on 13 February 86 separately to each candidate. We do not find the name of Shrimati Tungdeno Mozui in the recommendation of the selected candidates. However, the name of 1 T Audio is found mentioned in the list of qualified candidates called for interview and marks obtained by them interview. For clarity, the list of candidates called for the interview is reproduced here and below. And T Audio is me. That is actually me. Then 157 is the list of candidates who are called. My name is serial number 16, T Audio. Audio is the maiden name, Your Lordship. Then at the bottom of the page, there is no trace of record in the file to confirm that Shrimati Tungdeno Mozui, alias T Audio, has been selected through an interview board for regularization of her ad hoc service. So it notes this, the order also notes that Tungdeno Mozui and Tungdeno Audio are the same. The person has seal number 16. Then the IO, this is important here. The IO has called Shrimati Thungdana Mozui, alias Thungdana Oyo, to give her an opportunity to produce evidence and any other documents to prove that her service was regularized after successfully passing an interview. Now, the point here is, Your Lordship, an IO of the case, a police officer investigates criminal actions. Her statement before the IO is, I am to state that I was selected for interview serial number 16, where my name appeared as TODO. I am also to state that I was not given any appointment order of the interview, as my name did not figure in the list of candidates listed out by the selection board to be appointed as ABO. But I was informed to continue my service since a decision is going to take place, and I received order on 13/1/86, extending my ad hoc service till further orders. To another question, she stated, I am to state that I applied for the post of APO Gen, but I received the extension order as APO veterinary after the interview was conducted as I was selected. I did not receive any copy of regularization order, therefore I was not aware about the regularization order earlier. As regards the two contradictory orders of regularizing her ad hoc service and the other of extension of her ad hoc service as APO, she stated, I am to state I was not aware of the regularization order earlier, and therefore it might have been issued retrospective, backdated by the competent authority to the date of my extension order as I was selected. I am also to state that since my personal file is not in my custody, it is the prerogative of the authority to be answerable for the documents. So this is the point. I am not the custodian of my documents. My service records is with the authority. And the point is, again, which I was stressing earlier, this incident occurred when the petitioner's service was with the SRDA. The SRDA, the employees of the SRDA were absorbed into the Rural Development Department of the state of Nagaland in the year 1997. En bloc. All the employees. En bloc. So this is at a stage when they were not government employees, in a manner of speaking. They were in an agency. SRDA employees became proper government servants only after the year 1997. So in 1997, Your Lordship, the entire, I have those documents, I'll place those facts before Your Lordship later on. The entire block of SRDA employees, regular, non-regular, temporary, casual, en bloc, they were made into government servants, absorbed in the Department of Rural Development. Everyone. So with effect from what happened prior to 1997 is actually of no consequence anymore. That is the point I'm trying to make here. It may be true what the local actor is saying, may be true, may not be true. I'm saying it's not true. But for the sake of argument, it may be true, may not be true. But what happened prior to 1987 is of no consequence.
Okay, let's move on.
Yes, the bottom of the page, my lord. Mere perusal of the above statement of Shrimati Thungdana Mozui. Thungdana shows that her statement is contradictory and does not inspire confidence. Again, another point of note, Your Lordship, this is not a hearing which was taking place before the local actor. The local actor is simply relying on the report of the investigating officer, a police officer. In view of the above facts on record, we hold that the order dated 1st March 1986, regularizing the ad hoc service of Shri T. Mozui on successfully qualifying in the interview, is an illegal order and not tenable law. This is the point, Your Lordship. On what basis? This is absolutely perverse. Behind my back, a judicial order has been passed by a body which is coram non judice, which is not a court of law. Okay. Then next page, madam. We are informed that the Department of Rural Development has instituted an inquiry against Shrimati Thungdana Mozui. Now, if I may pause here for a moment. In terms of the scheme of the Local Actor Act, the Local Actor can recommend. So one of the recommendations which could have been given against me was that there is, in the report, that there is prima facie some ground of misconduct, so disciplinary inquiry should be conducted. Disciplinary inquiry should be conducted. Departmental inquiry. One of the recommendations could have been that. But without the recommendation of the local actor, an inquiry was instituted. This is the point here. Has instituted an inquiry against Shrimati T. Mozui as to the circumstances leading to two contradictory orders issued on the same day by the same authority, one order being extension of ad hoc service, and the other regularizing the ad hoc service of Team Mozui. The inquiry report was that no concrete evidence was found on the two orders to be true or false. However, the extension of the service was established from the relevant file. On receipt of the report, the RD department forwarded the file to the PR department for action. So an inquiry was conducted, and it was found that no evidence was there to suggest any wrongdoing on the part of the petitioner. The PNR department conveyed to the RD department, one, this is now after the inquiry report, place the official under suspension. Two, file criminal case against the official in the Nagaland Local Actor. Thereafter, suitable punitive action after receipt of recommendation of the Nagaland Local Actor. On a query, the Department of Rural Development by the letter dated 17/7/20 replied to the Local Actor investigation, which is reproduced here below. Now, this is the letter, 17 July. In inviting a reference to a letter dated 15/7/2020 on the subject cited above, and with regard to the departmental inquiry conducted against Shrimati T. Mozui, Project Director Wokha, I am directed to state that the Department of RD, in follow-up to the subsequent observations and advice rendered by the PNR, the department initiated instant suspension of the concerned official. Accordingly, the instant suspension draft was put up to the minister in charge and chief minister to obtain approval. The matter upon perusal by the chief minister was endorsed to the chief secretary to obtain views. Subsequently, the chief secretary commented for initiating disciplinary action against the concerned official whilst placing the service of the officer under suspension. Hence, the then Principal Secretary RD Department signed the final draft of the suspension order. However, before the suspension order could be dispatched, the direction was received from the high-ups to resubmit the file to the Chief Minister's office through the Chief Secretary for review. While the matter was pending review, comment from the Chief Minister's office, the incumbent attained superannuation age and the department released her from service with effect from 30/11/2019. Now, Your Lordship is aware, unless the rules provide after retirement, there can be no further inquiry. So obviously, the disciplinary proceeding was dropped. In our considered view, after looking into the facts of the case and on examination of all available records, the ad hoc service of Shrimati T. Mozui has never been regularized, and her service continued to be on ad hoc appointment, and as such, even the promotion to the post of DPO as recorded in the service book is not supported by any document and as such not tenable. This disposes of the case. So my service has been held to be illegal. A judgment and order has been passed to this effect by the Board Local Actor.
It was never regularized.
No, that is the finding. Never regularized. So it is my case now, my lord, as the lordship might have already understood the case of the petitioner. Local Actor has no jurisdiction to pass such an order. The only action which could have been, a report could have been submitted saying that there is prima facie some ground to suggest that her appointment is not proper, and that matter should be investigated by the concerned authorities.
What kind of recommendations that we can go on that?
Yes.
What kind of recommendations can be given? It's
Yes.
It's given in the act.
We can go through the provisions of the act.
Any fiscal. So this is the primary contentions that decision has been made rather than
Yes,
recommendation.
a judgment and order has been passed. It's not a report. It is not a recommendation. It is a judgment and order. That itself vitiates the order. Has your lordship got it, the copy of the act?
Yes.
If you can go to the definitions at section 2. F. At page 2F. Has your lordship got it? 2F, complaint. Complaint means a complaint made in such form as may be prescribed, alleging that a public servant has committed an offense punishable under the PC Act. This is important in leadership. The allegation must be that an offense has been committed under the PC Act. There is no allegation that an offense has been committed under the PC Act. Then, G. Grievance means a claim by a person that he suffered injustice or hardship as a consequence of maladministration. We are not concerned with this. The complaint is against me. It's not a grievance suffered by the respondent number 4. Investigation means an investigation as defined under clause H.
Criminal investigation.
Yes, criminal investigation. Preliminary inquiry means at N. At N, has the lordship got it?
Yes.
At N. Preliminary inquiry means an inquiry conducted under this act.
Nice.
So there's a criminal investigation and there's a preliminary inquiry. Nothing final, your lordship. Nothing final. Then your lordship can turn to section 8. Section 8. Just at page 8. Section 8. Matters which may be investigated by a loco actor or upa-loco actor. Subject to the provisions of this Act, the loco actor may investigate any action which is taken by or with the general or specific approval of the authorities from whom. Then 2, the loco actor or upa-loco actor may, if he thinks fit, investigate an action taken by or with the general or specific approval of a public functionary if it is referred to him by the state government. 3, the loco actor may, for reasons to be recorded in writing, investigate any action which may be investigated by an upa-loco actor whether or not a complaint has been made to the loco actor in respect of such action. 9, Section 9. Matters not subject to investigation. Except as hereinafter provided, the loco actor or upa-loco actor shall not conduct any investigation under this Act in cases of a complaint involving a grievance in respect of any action, A, if such action relates to any matter specified in the second schedule, or B, if the complaint has had any remedy by way of proceeding before any forum or other authority. So this is B is also there, am I not? If the complainant has or had any remedy by way of a proceeding before any forum or other authority, provided that nothing in clause B shall prevent the loco actor or upa-loco actor from conducting an investigation if the loco actor, or as the case may be, the upa-loco actor, is satisfied that such person could not or cannot for sufficient cause have recourse to such remedy. 2, the loco actor or upa-loco actor shall not investigate any action in respect of which a formal and public inquiry has been ordered under the Public Servants Inquiries Act 1850 by the state government or government of India. Any action in respect of a matter which has been referred for an inquiry under the Commissions of Inquiry Act 1952 by the state government or government of India. 3, the loco actor or upa-loco actor shall not investigate any complaint involving a grievance made after the expiry of 8 months of 12 months from the date on which the action complaint becomes known to the complainant. B, any complaint involving an allegation made after the expiry of 5 years from the date on which the action or conduct complained against is alleged to have taken place. Now, this is about 84. When the petitioner as well as the respondent before were under the SRDA. This is something which happened in the year 1984. March after 5 years.
5 years is one absolute, and then if it is sometimes not known to the complainant, then after he comes to know, 1 year.
That is the first case. That is the first case. That is about a grievance. That is about a grievance, Your Lordship.
Grievance.
And B is about the complaint. B is about the allegation. And in my case, we are concerned with B because there is an allegation against me. It's not a grievance of the respondent before. Provided that, so in the proviso to B, provided that the loco actor or upa-loco actor in respect of a grievance or allegation, as the case may be, so in both, may entertain a complaint made after the expiry of a set period if the complainant shows sufficient cause for not making the complaint within set period. In this case, no cause shown. Straight away, the complaint has been filed and the complaint has been entertained.
All right.
So my case is this in respect of the proviso. If there is a delay, there must be an application for condonation of delay under this proviso. The complaint,
the application aspect is not specifically mentioned, but cause has to be shown.
Yes.
Anyway, so
Yes. Then Section 10. Section 10 is a provision relating to complaints. Subject to the provisions of this Act, a complaint may be made under this Act to the loco actor in the case of an allegation by any person and in the case of a grievance by a person aggrieved, provided that where the person aggrieved is dead or is for any reason unable to act for himself, the complaint may be made or continued by his legal representative or by any other person who is authorized by him in writing in his behalf. Every complaint shall be made in such form and in such manner and shall be accompanied by such affidavit as may be prescribed. I have no idea what this complaint is. Till today, it has not been served to me. Notwithstanding anything contained in this Act or any other law for the time being in force, any letter written to the loco actor by a person in police custody or in jail or in any asylum other place for insane persons shall be forwarded to the loco actor unopened and without delay by the police officer or other person in charge of such jail, asylum or other place, and the loco actor may, if satisfied it is necessary so to do, treat such letter as a complaint made in accordance with the provisions of subsection 2. Then 11, provisions for holding preliminary inquiry. 1. The Lok Ayukta or the Upa Lok Ayukta, on receipt of a complaint or in case initiated on his own motion, may before proceeding to investigate such complaint or case, make such preliminary inquiry or direct any other person to make such preliminary inquiry as he deems fit. If on such preliminary inquiry he finds that there exists no such ground, he shall record a finding to that effect, and thereupon the matter shall be closed, and the complainant shall be informed accordingly. The procedure for verification in respect of a complaint under subsection 1 shall be such as a Lok Ayukta or Upa Lok Ayukta deems appropriate in the circumstances of the case and he may, if he deems it necessary so to do, call for the commence of the public functionary concerned. Then 12, procedure in respect of investigation. The Lok Ayukta or Upa Lok Ayukta shall in each case before it decide the procedure be followed for making the inquiry, and in so doing ensure that the principles of natural justice are satisfied. No compliance with the principles of natural justice here. Merely reliance on the report of the IO. Then 2. Okay. Subsection 2. The Lok Ayukta or Upa Lok Ayukta may, in his discretion, at any stage, refuse to inquire or cease to inquire into any complaint involving a grievance or allegation if, in his opinion, the complaint is frivolous or vexatious or is not made in good faith, or there are no sufficient grounds for investigating, or as the case may be, for continuing the investigation, or other remedies are available to the complainant, and in the circumstances of the case, it would be more appropriate for the complainant to avail such remedy. In the facts of the case, Your Lordship, there were other remedies available. In the facts of the case, there are other remedies available.
Anyway, so for the
Yes,
point of view of the complainant.
Yes, my lord. Then, provided that the Lok Ayukta or Upa Lok Ayukta shall record his reasons in thereof and communicate the gist of the order to the complainant and the public functionary concerned. 3. The Lok Ayukta or Upa Lok Ayukta, as the case may be, shall have power to review his order or decision to restore any matter closed at any stage and to grant or refuse permission to the complainant to withdraw the complaint, provided that the Lok Ayukta or Upa Lok Ayukta shall record his reasons in writing, therefore. Then, section 14, evidence. It's page 12, section 14. Subject to the provisions of this section, for the purpose of any investigation, including the preliminary inquiry under this Act, the Lok Ayukta or Upa Lok Ayukta may require any public functionary or any person or authority who, in his opinion, is able to furnish information or procedure documents relevant to this investigation and inquiry, to furnish any such information or produce any such document, and such public functionary, person, or authority so required shall be deemed to be legally bound to furnish such information within the meaning of section 176 and 177 of the IPC. For the purpose of any such investigation, including preliminary inquiry, Lok Ayukta or Upa Lok Ayukta shall have all the powers of a civil court while trying a suit under the Code of Civil Procedure with respect to the following matters. So the subjects under which the powers can be exercised. Then 3, any proceeding before a Lok Ayukta or Upa Lok Ayukta should be deemed to be a judicial proceeding within the meaning of section 193 and 228 of the IPC. 4, no person shall be required or authorized by virtue of this Act to furnish any such information or answer any such question or produce documents as might prejudice public interest or security of the state or the security or defense or internal relations of India, as might involve the disclosure of proceedings of the cabinet of the state government or any committee of that cabinet, provided that a certificate to this effect is issued by the chief secretary. Provided further that the Lok Ayukta or Upa Lok Ayukta, as the case may be, require any information or answer or portion of a document in respect of which a certificate is issued under this subsection to the effect that it is the nature specified in clause A or clause B to be disposed of in private, to be disclosed to him in private for scrutiny. If on such scrutiny the Lok Ayukta or Upa Lok Ayukta, as the case may be, is satisfied that such certificate ought not to have been issued, he shall declare the certificate to be of no effect. Now the point is this, Your Lordship, the evidence is to be taken by the Upa Lok Ayukta or the Lok Ayukta. The Upa Lok Ayukta or Lok Ayukta cannot rely on the evidence, so-called evidence collected by the IO of the case. And to collect evidence, to collect evidence, the Upa Lok Ayukta or the Lok Ayukta has the powers of a civil court. Then,
on its own, through its internal mechanism.
Yes, my lord.
Evidence through its
Yes.
internal mechanism, as per the CPC.
Yes, my lord. Then section 15, interim recommendation. If during the course of a preliminary inquiry or investigation under this act, the local actor or upper local actor is prima facie satisfied that the allegation or grievances against any action is likely to be substantiated, either wholly or partly, he may, by a report in writing, recommend to the public functionary concerned to state the implementation or enforcement of the decision or action complained against, or to take such mandatory or preventive action on such terms and conditions as he may specify in his report. So recommendation, and the extent of his recommendation is also mentioned here, Your Worship. Then section 16 is the interim report now.
This is the interim recommendation.
Yes, section 15 is interim recommendation. Section 16 is interim report. The local actor or upper local actor, as the case may be, may forward an interim report to the competent authority recommending, again, Your Lordship, grant of interim relief to the complainant if he is satisfied at any stage of preliminary inquiry or investigation that the complainant has sustained injustice or undue hardship in consequence of any action, decision or action of a public functionary, and that the grievance complained of should be redressed expeditiously. 2, the local actor or upper local actor, as the case may be, may at any stage of inquiry or investigation under this act forward an interim report to the competent authority recommending to take such action as may be considered necessary by him against the public functionary pending inquiry or investigation. Again, Your Lordship, recommend such action may be taken pending inquiry or investigation to safeguard wastage, etc. Then section 19. Section 19. Is the Lordship got section 19? Secrecy of preliminary inquiry or investigation.
But this interim recommendation would be by way of stay.
Something like that.
Something like that.
Something like
Final recommendations are
yes, something like that.
19.
Yes.
Secrecy of
Section 19.
preliminary.
Every preliminary inquiry or investigation on this act shall be conducted in private, and in particular, the identity of the complainant and the public functionary affected by the preliminary inquiry or investigation not be disclosed to the public or the press or published in any manner before or during the preliminary inquiry or investigation, provided that the local actor or upper local actor may, in his discretion, for reasons to be recorded in writing, allow the publication or proceeding of this investigation or a part thereof at any stage of the proceeding. Now, resorting to this section, till today, I have not been given a copy of the complaint. And what this particular section bars is only disclosing the identity of the complainant. The substance of the complaint can be given to me, Your Lordship. There is no bar. Then section 20 also, Your Lordship, secrecy of information. Any information obtained by the local actor or upper local actor or the manner of or the member of his staff or any other person or agency referred to in section 16 in the course of or for the purpose of any preliminary inquiry or any investigation under this act, and any evidence recorded or collected in relation to such information shall, subject to the provision of section 19, be treated as confidential. So these are the sections under which I have been denied even a copy of the complaint. And notwithstanding any contained in the Indian Evidence Act, no court shall be entitled to compel the local actor or upper local actor or any such member, person or agency or any public functionary to give evidence relating to such information or to produce the evidence so recorded or collected. Nothing in subsection 1 shall apply to the disclosure of such information or evidence, A, for the purpose of any report to be made under this act, or for the purpose of any action or proceeding to be taken on such report. So there is a provision for giving me, after the report has been filed, there is a provision for giving me a copy of the complaint. Till today, still no such report has been given to me. Okay. Then all the subsections are related to this. Then we can come straight away to section 25. Section 25. Reports of local actor or upper local.
Final reports.
Yes, ma'am. This is the final report. 1A. If after investigation of any action involving a grievance, the local actor or the upper local actor, as the case may be, is satisfied that such action has resulted in injustice or undue hardship to the complainant or any other person, the local actor or upper local actor shall, by a report in writing, recommend. In the final report also, it is recommend to the competent authority concerned that such injustice or hardship shall be remedied or redressed in such manner and within such time as may be specified in the report, including 1, that any practice on which a decision, recommendation, act, or omission was based should be altered or reviewed, or that any law on which a decision, recommendation, act, or omission was based should be altered or modified, or the reason should be given for any decision, recommendation, act, or omission, or that any other steps is legally permissible, as is legally permissible, may be taken. This is in respect of a grievance. The competent authority to whom a report is sent under subsection 1 shall within 1 month of the expiry of the period specified in the report intimate or cause to be intimated to the local actor or people local actor, as the case may be, the action taken on the report. 3.
Is relevant.
Yes, 3 is for us in complaint.
In this case, there's an allegation.
Yes, this is the allegation. If after investigation of any action involving an allegation, local actor or upalocal actor, and your lordship will also remember the definition. The definition is a complaint. Allegation is allegation of offense under the PC Act. If after investigation of any action involving an allegation, the local actor or upalocal actor, as the case may be, is satisfied that such allegation is substantiated, either wholly or partly, he can only say it is substantiated either wholly or partly. He shall, by a report in writing, communicate his findings and recommendations. Communicate his findings and recommendations, along with the relevant documents, materials, and other evidence to the competent authority concerned. Recommendations. 4A, the competent authority in the case of a public functionary other than the chief minister, etc. So this is about the ministers, we're not concerned with that. And B, is also about chief minister and MLAs. And C, 4 is about members of the assembly, so not concerned. 5, if the local actor or upalocal actor, as the case may be, is satisfied with the action taken or proposed to be taken on his recommendation referred to in subsection 1 or subsection 3, he shall disclose the case on the information to the complainant, if any, the public functionary and the competent authority concerned, but where he is not so satisfied, and if he considers that, yes, then he has to submit the report to the government. That is all. So findings and recommendation to the competent authority. If he's not satisfied on the action taken, submit the report to the government. That is the extent of his powers. He cannot pass a judgment and order. He cannot conduct an inquiry behind my back and come to findings that my appointment order is illegal. He cannot collect evidence. He cannot rely on evidence which is collected by a police officer and then come to such findings.
Oh, he can come to a finding perhaps regarding, if that is the question, that whether the appointment was proper, whatever the conduct. So he can come to a finding regarding that, and then perhaps recommendation.
Make a recommendation. But he cannot hold, my lord, he cannot hold that my appointment is illegal. He cannot.
Wholly or partly substantiated.
Just substantiated.
Use.
Yes. Substantiated. It's not proved. It is not about proving your ownership. The local actor is not a court in terms of the scheme of this act. Okay. So that is the case, Your Lordship. That is the case. Now, if I take Your Lordship to the brief facts of the case. Your Lordship is aware of the provisions of the PC Act, so not necessary to go into it.
Not necessary.
I'll give a copy.
But we can see always we refresh. So let's
Yes, Your Lordship.
see the facts.
We'll go to the fact.
You joined in 1984, right?
1984.
November 1984.
Yes.
Okay, yeah, well, let's go.
We'll go to the facts, man.
Yeah.
Page 5, page 5 of my petition. So by an order dated 28/11/84.
Page 5 of your petition.
Yes, my lord.
This petition. Right?
Yes. The facts beginning from paragraph 3.
That by yes.
Yes. So paragraph 2 is about the SRDA. So it was initially called, the program was called the Small Farmers Development Agency. And then this evolved into the District Rural Development Agency and then the State Rural Development Agency.
True.
Then by
Order dated
28/11/84, appointed on ad hoc basis as Assistant Project Officer. Then paragraph 4, advertisement dated 16/8/85. 6 posts of APOs advertised by the SRDA. And advertisements at page 28 to 34, Your Worship. Then both the petitioner as well as the respondent number 4, we both appeared.
right.
And the orders, copies of the orders at page 1386. May I read this paragraph?
Yes.
That the petitioner, the petitioner as well as the respondent number 4 participated in the selection process. They were both called for the oral interview. Thereafter, by order dated 13/2/86, the respondent number 4, kindly note the date, Your Lordship, 13/2/86, because this is relevant insofar as the respondent number 4 is concerned. 13/2/86, the respondent number 4 was appointed as an APO on regular basis. In the case of the petitioner, for reasons best known to the respondents, 2 orders of even number and date were issued. One dated 1/2/86, by which her service was regularized, and the other of the same date by which her appointment was extended until the further orders. Then 6, both of them began working as colleagues in the same office at Kohima. This is important, Your Lordship. It's not as if they worked in different offices. They were working in the same office in Kohima. Both of them served as APOs. What I'm saying here is this, Your Lordship, in this paragraph, that after the issuance of their respective appointment orders, the petitioner and the respondent number 4 as colleagues began working as APOs in the office of the SRDA at Kohima. That is to say, both of them began serving in the same office. The fact that they were both appointed on regular basis through the selection process was well known to each of them and to the employees of the SRDA. The existence of 2 orders in the case of the petitioner was known to all in the office, including the respondent number 4. The regularization of her service was never questioned. Subsequently, by order dated 9/11/92, the petitioner was promoted to District Project Officer. Then this is what I was saying earlier about 1997, paragraph 7, Your Lordship. That in the year 1997, the state respondents decided to absorb the SRDA into the Department of Rural Development. Pursuant thereto, by notification dated 24/7/97, 200 posts were created for the purpose of absorbing the SRDA, DRDA employees, and thereafter by notification dated 25/7/97 issued by the Department of Rural Development, the date of absorption was notified as 16/97. This is the date. This is the date on which the SRDA employees became employees of the state government. Next paragraph, my lord. That from 16/97, the petitioner became an employee serving under the government of Nagaland in the Department of Rural Development. Effectively, the petitioner's career as a public servant began on this date. So the point I was trying to make earlier, what happened prior to 1997 is of no consequence anymore.
Only from 1697.
Only from 1697, a new chapter began in my career. Not only in my case, but in the cases of all the employees who were then serving under the SRDA. If there was any irregularity, any infirmity in their services, it was corrected, it was cured by the order of 1697, by the order of 25/7/97. And what happened in the SRDA became a closed chapter. Then 9, this is important, Your Lordship. This is where the problems between the petitioner and the respondent number 4 began. That as earlier stated, the respondent number 4 was appointed on an ad hoc basis by order dated 27/84, and she began serving on 21/7/84. Stating that she was appointed through a selection process in 1982, she claimed that her date of regular service should be counted from 21/7/84. She filed WPC 49K/2000, praying for the counting of her service seniority from the said date. It was her specific case that her appointment order on ad hoc basis was erroneous and that she had been in continuous service on regular basis from 21/7/84. The seniority and grade of ABO should count from the said date. By a judgment and order dated 2/8/2002, her writ petition was rejected. Now, we were all absorbed together, Your Lordship. And as far as my service and the respondent number 4 service, we were appointed on the same day, more or less. After the absorption in state service, the issue of seniority arose, service benefits, promotional avenues, and she desired her seniority to count with effect from the date of initial appointment, 21/7/84. And she put forward a claim that through a selection process held in the year 1982, she was appointed and therefore her seniority should be counted from 21/7/84. This was rejected. Now, the point of note is this, Your Lordship, kindly note, he claimed her seniority with effect from 21/7/84. Kindly note that date. Next paragraph.
This was our date of appointment on ad hoc basis.
Yes,
According to you.
yes. And the records are there.
Because
Records are there.
anyway, so
Then paragraph 10. That subsequently, for the purpose of extending her years in service. Now, this is again, and this is the follow-up of what happened earlier. That subsequently, for the purpose of extending her years in service, the respondent number 4 submitted a representation claiming that she was appointed pursuant to the selection process conducted in the year 1985, and the date of her appointment on regular basis should be taken as 1/3/86. So that is after she was absorbed. He also relied on a purported resignation letter to support her claim that her appointment with effect from 1/3/86 was a fresh appointment. Ad hoc service, Your Lordship, she participated in the selection process and she was selected. So he now says that she resigned and participated in the selection process, and therefore her seniority should be counted with effect from 1/3/86, the date of regular appointment.
not from this
No,
21/7.
no, not from 21, not anymore.
Day after.
Yes. So she changed her story now.
So the new prayer.
Yes.
1986.
Okay. So she wanted to gain about 2 years of service, length of service. Now, this affected us, not just the petitioner, but all those who were in the zone of consideration for promotion, because she was our immediate superior. If she retired from service, as per her due date, all of us would be in line for consideration for promotion. Paragraph 11, that this development in favor of the respondent number 4 would adversely affect the service of the petitioner and her colleagues. As such, they too submitted representations contradicting and contesting the claim of the respondent number 4. In the process, for the very first time, after the lapse of more than 30 years, the respondent number 4 filed a complaint alleging that the order recognizing the service of the petitioner is fake. Fortunately, a copy of the complaint has never been furnished to the petitioner. So after we started submitting representations against her claim for counting her length of service from 1/3/86, she took me as to be the ringleader because I was immediately below her, and she filed this complaint against me. Then 12, that the complaint was filed departmentally, pursuant to which an inquiry was initiated by memorandum dated 17/7/2019. Articles of charge were framed against the petitioner. On receipt of the aforesaid memorandum, the petitioner submitted a written statement on 22/7/2019. Needless to say, the petitioner denied all the charges against her.
The DP was drawn against her.
Yes, charges were framed. I submitted my written statement. So going by this fact alone, the law collector could not have proceeded with the investigation or inquiry into the complaint.
Anyway, so the DP proceeded to
Yes.
summoned to appear.
Yes. Next, paragraph 13. That the petitioner was summoned to appear in the disciplinary proceedings on 30/8/2019. The inquiry was held in the office chamber of the inquiry officer. It began at about 11 a.m. and concluded by 12 noon. In the presence of the presiding officer and the defending officer, the inquiry officer alone questioned the petitioner in relation to the charges framed against her. No other persons were present. The presiding officer did not present any case against the petitioner. No witnesses were examined and or cross-examined, and no documentary physical evidence whatsoever was placed for the consideration of the inquiry officer. As earlier stated, at the course of the petitioner was questioned on the charges by the inquiry officer alone. Thereafter, the petitioner did not receive any further summons. No further summons. Then, that having reached the age of superannuation, by order dated 30/11/2019, the petitioner was released from service with effect from 30/11/2019. Till the time of superannuation, the petitioner did not receive any further information about the inquiry proceedings. The petitioner is completely in the dark as to the outcome, if any, in relation to the disciplinary proceedings. So apparently it was not proceeded with. It was dropped. And it should have been dropped since she retired. There was no conclusion to the disciplinary proceedings. Next, paragraph 15. That the decision of the state respondents to treat respondent number 4's entry into service as 1386 was in violation of the Nagaland Retirement from Public Employment Act 1991. So this act requires, Your Lordship, age of either reach 60 years of age or 35 years of service, whichever is earlier. For retention in service beyond the prescribed age of superannuation would adversely affect the service careers of almost all the officers in the Department of Rural Development, including the petitioner. As such, the petitioner and 7 others filed WPC 55K of 2019. By a judgment and order dated 26/7/2019, this Honorable Court was pleased to quash and set aside the impugned action of the state
Appeal and then Supreme Court. Now it's,
Pardon me, madam?
the writ appeal was also dismissed.
Yes.
The writ appeal. And
Yes.
now it's pending in Supreme Court.
Pending in the Supreme Court. Yes.
SLP has been admitted.
Yes, ma'am. Then paragraph 16. What happened was, Your Lordship, the state respondents considered and they gave her 86 as the date of entry to service. So we challenged that. Then 16. The respondent number 4 had been submitting complaints against the petitioner. Her obvious intention was to browbeat the petitioner into submission. One of her complaints was filed before the Nagaland Lok Ayukta. The petitioner was summoned by a police officer in the office of the Nagaland Lok Ayukta in the rank of sub-inspector who claimed to be the eye of the case. The summons were for her appearance before the said officer on 3/2/2020 and 24/2/2020. On answering the summons, the said officer questioned the petitioner and directed her to submit her personal files, service book in origin, and also to explain how there were 2 orders with regard to her service: the order of extension and the order of regularization. The petitioner submitted all original documents requisitioned and answered the questions put to her. In the course of attending to the summons, the petitioner requested a copy of the complaint filed by respondent number 4. However, the request was flatly denied on the ground that the complaint is confidential. Having attended the summons, the IOSI informed the petitioner that she would be further summoned as and when necessary. Thereafter, the petitioner received no further summons and no notices from the Nagaland Lok Ayukta or the IOSI conducting the inquiry. Pertinently, from the inception, the petitioner has not received any summons, notices under the hand and seal of the Lok Ayukta. Not even once. Not even once was she ever summoned by the Lok Ayukta or Open Lok Ayukta. The petitioner also did not appear before the Nagaland Lok Ayukta either personally or through authorized representative on even a single occasion in response to the complaint filed by the respondent number 4. So the judgment and order was passed by the Lok Ayukta without any proceedings, apart from the fact that no judgment and order could have been passed.
She appeared, no, isn't it? Initially she appeared.
Before the IO.
Before the IO.
Not before the Lok
Her
Ayukta.
statement is also reflected.
Yes, before the IO, not before Lok Ayukta. The Lok Ayukta never summoned the petitioner even once.
That's your point.
Yes. That during the pendency of the aforementioned writ appeal, an affidavit was filed by the respondent number 4, enclosing the order dated 8/10/2020 passed by the Nagaland Lok Ayukta in case number A 2019. The respondent number 4 sought to rely on this order to avert that since the petitioner's appointment was illegal, she has no locus standi. So even the order of the Lok Ayukta was pressed into service in the writ appeal before the division bench of this Honorable Court. And yet, the writ appeal was dismissed. That thereafter, by letter dated 22/10/20, the petitioner was endorsed a copy of the order dated 8/10/2020. Since the appeal filed by the respondent number 4 was pending, the petitioner decided to wait. Next, 19, that on receipt of the order of the Nagaland Lok Ayukta, the petitioner requested a copy of the complaint filed by the respondent number 4. The aforementioned IOSI informed the petitioner that he would have to discuss the matter with his superiors. The petitioner last met with the IOSI sometime in November-December 2020. Her request was yet again denied on the ground that the complaint is confidential. That subsequently, by letter dated 1/2021, the petitioner submitted a request to the Nagaland Lok Ayukta, praying for a copy of the complaint. However, the request was ignored. Resultantly, the petitioner submitted an application dated 23/2/2021 under the RTI Act requesting a copy of the complaint. By letter dated 4/3/2021, the petitioner's application was rejected. Even the resort to the RTI was of no avail. The request was rejected. Then, so this is my case. This is my case. The Lok Ayukta, the powers of the Lok Ayukta under the Act of 2018 are only recommendatory. You can submit the report, either preliminary or final report, and the report can contain findings and recommendations, nothing more. That is my case. May I place certain authorities for your Lordship's consideration? One is that, No, where is the one about it? There is a interesting judgment here. This is apart from the one which I've already relied upon, which I've already placed Justice Devashil Parwar's judgment, there is a judgment of the Kerala High Court of the Division Bench, which went up to the Supreme Court. And the Supreme Court also dealt with it on the same issue about the loco-acta.
All states have this loco-acta.
Yes, yes, and similar provisions. All just loco-acta has only recommendatory powers, nothing more.
Similar provisions.
This is by Division Bench of the.
This is the Kerala High Court.
Yes, and this matter went up to the Supreme Court, and I'll place that also, Your Worship. Yeah. But maybe first go through the order of the Kerala High Court, Your Worship. By this writ petition is a short judgment. The Kerala High Court. By this writ petition, the petitioner challenges exhibits P4 and P6 being orders passed by the loco-acta in complaint number such and such. It may be noted that the said complaint was filed by the writ petitioner herself. We have heard learned counsel appearing for fifth respondent, who is the sole private contesting respondent, learned counsel appearing for the petitioner as well as learned government pleader, and with their consent, we are disposing of this matter at this stage itself. It appears that the father of the writ petitioner and fifth respondent left behind certain properties, part of which was given to one or the other family member, and part of it was allegedly intended to be kept in the state of joint owners. Amongst co-sharers, there were some disputes which led to the institution of OS before the Mudsev's court, Thiruvananthapuram, by fifth respondent, in which the petitioner is a defendant. In the suit, the plaintiff had obtained an injunction restraining the defendant, the writ petitioner, from changing the nature of the property in any manner. It appears sometime thereafter, the writ petitioner alleged that on the basis of certain forgeries committed by fifth respondent or at her behest, wrong entries were being sought to be made in the revenue records of the state in respect of part of the property which was the subject matter of the suit. The writ petitioner defendant in the suit then moved the Upaloka by the instant complaining about alleged maladministration by revenue authorities in a matter of mutation as allegedly got done by the plaintiff, who is the fifth respondent here. So this was the case. In those proceedings, the writ petitioner invited the attention of the Upaloka to the facts and sought orders against the maladministration as alleged. Upon notice of the parties and hearing them, the Upaloka passed orders which are imputed herein as exhibits P4 and P6. Those orders are positive directions. Yeah, Your Lordship. No positive directions can be given. Those orders are positive directions to the revenue authorities and are substantially gone against the petitioner who was the complainant. The submission on behalf of the writ petitioner is that in the facts and circumstances of the case as noted above, the Upaloka did not have the jurisdiction to entertain the complaint, and consequently, the orders passed are out of jurisdiction. Secondly, he submitted that in terms of Section 12 of the Act, the Loco Actor or Upaloka Actor has no jurisdiction to issue positive direction. Same thing, Your Worship. The aforesaid provision, and in particular subsection 1 thereof, comments that the Loco Actor or Upaloka Actor would submit a report in writing to the appropriate authority with their recommendation. Thus, it is only an advisory order, but not a peremptory order that could be issued. We have considered the arguments of learned counsel appearing on both sides. The learned counsel of the fifth respondent was also contesting the respondent before the Upaloka Actor, who is the plaintiff in the suit, has fairly conceded that the complaint as filed by the writ petitioner could not be entertained by the Upaloka Actor in the facts and circumstances of the case. Thus, the petitioner and the contesting respondent are ad idem on this issue, which in our view is the correct position. Loco Actor cannot pass any positive ideas. The matter relates to a civil dispute which is pending before a court of competent jurisdiction, where both the parties have appeared. The nature of the dispute is such that it has to be adjudicated by the civil court. Thus, the matter being substantially sub judice before the civil court, in our opinion, the Upaloka Actor ought not to have entertained the complaint at all and left the parties to avail all the remedies as per common law. Even if both the parties move the Upaloka Actor, it is well established that consent cannot confer jurisdiction, where there was inherent lack of jurisdiction on the part of Upaloka Actor to entertain such a complaint. Even if both the parties agreed, jurisdiction could not be conferred, but the statute does not provide for it. We would like to put in a word of caution here as well that wherever disputes are taken before appropriate designated forums and are pending or have been resolved in the manner as provided by law, Lok Ayukta or Upa-Lok Ayukta would not have jurisdiction in the matter. So there was already a disciplinary proceeding pending, Lordship. Lok Ayukta and Upa-Lok Ayukta are not appellate or supervisory authorities over other competent forums created under different statutes, because each of those statutes provides its own remedial steps like repeal, revision, and otherwise. Parties have to follow those procedures, and their remedies are to be worked out on the basis of those statutory provisions. And there is nothing in the Lok Ayukta Act which should override those procedures or forums, giving Lok Ayukta the right to override orders statutorily passed by statutory authorities. This would include civil court of competent jurisdiction. Thus, in our opinion, the complaint ought not to have been entertained by the Lok Ayukta. That being the position, the proceedings before Lok Ayukta were wholly without jurisdiction, and consequently, the orders passed therein cannot be held to be legal, valid, and binding. In view of the aforesaid, the writ petitioner seeks liberty to withdraw a complaint made before the Lok Ayukta in order to move the civil court or such other competent authority as the petitioner may be advised. Leave is granted. Accordingly, the complaint filed before the Lok Ayukta would thus stand withdrawn. While on this, we would also like to notice the second limb of argument of the legal counsel that Lok Ayukta was not competent to issue positive directions. In our view, a plain reading of Section 12(1) of the Act makes this position clear. He can only make a report to the concerned authority with recommendation. Same thing with us, Section 25.
In this case, that's true. That's okay. In this case, the Lok Ayukta has made a positive finding.
Positive directions, Your Lordship, insofar as relates to revenue records.
Here.
Yes.
Yeah. No. In your case, this case, our case.
So in my case, the Lok Ayukta has come to the conclusion.
Finding. He has recorded
a finding. Yes.
He has recorded a finding.
He has passed a judgment and come to the finding that my appointment.
No positive direction has been given, but a positive finding has been recorded.
Positive finding has been given. And not only that, Your Lordship.
Subject to one.
Yes, not only that. The positive finding is in effect a positive direction. In effect, it is a positive direction. Because once there is a conclusion, a finding that my appointment is illegal, it has consequences.
Okay.
Then this case was referred to by the Honorable Supreme Court, Lordship, and it went up to the Supreme Court. It was referred to by the Supreme Court in another case. And this is the Supreme Court judgment. Your Lordship has that, the Supreme Court judgment? Yes. Addition to Tehsildar and other. Yes. Paragraph 3. The appellants have challenged the order passed by the High Court whereby... First page, Your Lordship.
Okay.
The appellants have challenged the order by which the High Court whereby the writ petition filed against the order passed by Upa-Lok Ayukta in the complaint filed by respondent number 1 was dismissed. 4. Brief facts as available on record are the respondent number 1 filed a complaint with the Lok Ayukta narrating long history of the revenue record pertaining to the land with a grievance that the revenue record was not being corrected and for a direction be issued to the respondent therein for correction thereof and also to mutate the land in question in the name of the legal heirs of late K. Gopalakrishnan, etc. Upa-Lok Ayukta filed cryptic order dated 18/10/2016 directed Tehsildar Varkala to rectify the mistake in the revenue records and also receive tax from the complainant. So, from the complainant, the order was to be complied with positively within 1 month, and such compliance was to be reported on 16/11/2016. Aggrieved against the order, the appellants filed writ petition in the High Court, which was dismissed. The learned counsel for the appellants submitted that the order passed by the Lok Ayukta was totally without jurisdiction, while it issued positive directions for correction of revenue records and also to receive tax for which statutory authorities have been prescribed under the Act and rules. Lok Ayukta is not a supervisory body above the statutory authorities in hierarchy under the aforesaid statutes. The jurisdiction given to Lok Ayukta was only to address the issue of maladministration. However, without addressing that issue in the order, it traveled beyond its jurisdiction to deal with the matter on merits. So it dealt with the matter on merits, even in our case, Your Lordship, and issued positive directions for correction of revenue records. Hence, the orders passed by the High Court as well as Upa-Lok Ayukta deserve to be set aside. Now, if the point is this, in my case, Your Lordship, the Upa-Lok Ayukta heard the matter as if a case was being heard. And the case was decided on merits. And on merits in my absence. and came to a conclusion, came to a finding which the local actor had no jurisdiction. Then 6, a perusal of the paperbook shows that despite service, the respondents remain unrepresented. 7, Section 12 of the 1989 Act deals with the reports of local actor. It provides that in case local actor or local actor is satisfied with any action or inaction of the party which has resulted in injustice or undue hardship to the complainant, it shall, by a report in writing, recommend to the competent authority to remedy such injustice or hardship. From the facts available on record, in a perusal of the complaint which was filed by respondent number 1 before local actor, it is evident that the grievance raised was regarding correction of the error in the revenue records of the report in survey number such and such, and also to mutate the same in the name of legal heirs of K such and such. It was pleaded that the inaction on the part of the respondents in the complaint in rectifying the mistake amounted to maladministration, which should be investigated by the local actor. The complaint was filed in June 2016. Long history pertaining to the land was given while pointing out the errors in the revenue records. The complaint also mentioned that the request of respondent number 1 for rectification of the defect in the revenue records was declined by the additional Tehsildar by order dated 19/4/2016. However, nothing was mentioned if any action was taken by respondent number 1 to challenge the aforesaid communication. The relevant claim in the aforesaid complaint filed before a local actor is extracted below. Direction may be given to the respondents to rectify the error in the revenue records in respect to the property in survey number such and such, owned and possessed by late Nair, by correcting it as instead of such. 2. Direction may be given to the 4 respondents on another direction. Then paragraph 9. Insofar as the jurisdiction of local actor is concerned, a division bench of the High Court in Suradevi, this is the previous case which I was relying upon, had opined that in terms of Section 12(1) of the 1999 Act, local actor was not competent to issue positive direction. He can only submit a report with the concerned authority with its recommendations. They only have recommendatory jurisdiction. This is important. They only have recommendatory jurisdiction. They do not have any authority to come to any findings. They can only say that the allegation is substantiated, either wholly or partly. A local actor or upa-local actor is not appellate or supervisory authority over other competent forums created under different statutes, as each of those statutes provides its own remedial steps such as appeal, revision, etc. The parties need to follow that procedure. The 1999 Act is not meant to override those procedures. The aforesaid judgment of the division bench of the High Court was referred to in the case in hand, however, the same was ignored. 10. In a subsequent judgment in District Collector, the division bench of the High Court reiterated the law laid down in Suradevi. That's the same case again. It was opined that the complainants therein had not availed the statutory remedies regarding rectification of mistakes in the revenue record. When a relevant statute provides for a hierarchy of remedies, those should have been resorted to. The action of the local actor was found to be without jurisdiction. In our view, in the aforesaid 2 judgments of the High Court, the provisions of the 1999 Act were rightly interpreted, upheld by the Supreme Court. However, in the case in hand, direction issued by the local actor for correction of the revenue records was upheld, which goes totally beyond the jurisdiction of the local actor. The direction given by the upa-local actor in the summary order is extracted below. So the direction given to rectify. Then, paragraph 12. Paragraph 12. There is nothing on record to show that respondent number 1 had either availed of any appropriate remedy against the communication dated 19/4/2016, by which the request for rectification of record was rejected, or any other appropriate remedy for correction thereof. So, for the reasons mentioned above, in our view, the order passed by the High Court as well as the upa-local actor cannot be legally sustained. No positive orders can be issued. No findings can be established. Findings can either only be said to be substantiated partially or wholly. And on that finding of either wholly or partially being substantiated, a report must go containing recommendations. Nothing more. So that is my case. And there's one more authority which I wish to rely upon. This is 2001 9 ACC 7. I've cut out the principle, no need to go into the text. And the principle is that there can be no condition of delay without an application for the same. So there must be
application for the same.
Yes, there must be.
This holds the field still.
Yes, still holds the field. Yes.
Suppose the grounds of delay are incorporated in the main petition itself.
An argument could be made that yes, but there is no such ground taken. Nothing. Just to all effects and purposes, just a complaint filed.
We'll see now.
And as I was saying earlier, Your Lordship, till today, I don't know what the complaint is. So that is my case, ma'am. May I rest for a moment?
Short break. 2 minutes. You're appearing for the. Sir, you're appearing for.
Lordship, I am appearing for respondent number 5. Look at that, though. Though I have made a performer arrayed as a performer respondent, Lordship, the order and the challenge is my order. So I have to.
So 1, 2, 3, 4. All are represented. Commissioner and Secretary. Ma'am, you are appearing for.
For 1, 2, 3,
What?
6.
For this.
103.
I'm 4.
Yeah. It's a. Just 3 minutes. We also have a.
Not necessarily make you a party also.
Without sharing tea.
Not necessarily make you a party also.
was a charge sheet before the Learned Special Judge PC Act, Nagaland Law is non-est and requires to be interfered with. So accordingly, the charge sheet was interfered with, Your Lordship. Now, 19.4, the last para. The court observed for further clarity that this court had not interfered with the investigation. This court has only observed that upon the investigation carried out by the Office of the Local Government of Nagaland, the power conferred under the Act of 2018 is recommendatory in nature, and the report submitted by the state the government of, it should be Nagaland, not government of Assam.
That's okay.
On basis of an investigation carried out such and such. So, Your Lordship, what I would like to impress upon Your Lordship is that this honorable court did not interfere with the investigation carried out by the Lokata, but only said that no, Lokata cannot submit any charge sheet because it is not a police station, nor they are police officer who are the authority to file charge sheet. Lokata, at best, it can submit recommendation. So that's all. Now, on the jurisdiction of Lokata, Your Lordship, the subject matter in this complaint, Your Lordship, relates to condition of service. That is, forging, fabricating, regularization order, conditions of service. Your Lordship. And for that, the relevant provision under the Lokata Act on investigation jurisdiction is Section 9, Your Lordship. My learned counsel for the petitioner has already taken Your Lordship to that.
Yes.
So I will not trouble Your Lordship.
We can see it again, just briefly. Yes.
Section 9.
Yes, Section 9. Yes. Matter not subject to investigation.
Lordship.
Okay.
Except as enough to provide Your Lordship. So here, Your Lordship, relevant provision is Section 9A, read with second schedule. The second schedule, Your Lordship, last page, Lordship has got it. Second schedule. D. Action taken in respect of appointment, removal, paid, discipline, subordination, or such and such. Except, Your Lordship, complaint involving litigation.
For monetary claims, explicit.
On Section 9, jurisdiction of Lokata, on Section 9, Your Lordship, this honorable court in read appeal, in both read appeal, 1 and 41 of 2024 and 41 of 2025 has dealt with it, Your Lordship. May I take Your Lordship first to read appeal 1 of 2024. This is a judgment dated 29/5/2024. Relevant para, Your Lordship, let me just read some few paragraphs.
The read appeal, huh?
Yes, read appeal 1 of 2024.
Para 16?
Para 2, 8, 9, 16, and 17. This is a short paragraph, Your Lordship. Para 2, the writ petition was issued against such and such on behalf of Nagaland, whereby the appeal of the writ petitioner to invoke the provision of Section 9 was rejected and the matter was decided to be proceeded further. Your Lordship, before the Lokata, Your Lordship, the petition hearing has raised on the issue of jurisdiction by relying on Section 9, but the Lokata held that no, it is not barred and proceeded. So that order has been challenged. Para 4. Now, para 8, Your Lordship. So, it is submitted that in the instant case, a complaint was lodged by a third party. Like in the instant case, Your Lordship, the complainant is the third party. Respondent number 4. Alleging that the writ petitioner were overstaying in service. In the present case, it is forging regularization order. And that the matter of inquiry by the authority, it is in this context that the writ petitioner has made submission that such complaint would be barred under Section 9 of the Act of 2017, and the said submission was rejected by the order dated 7/12/2022, which was passed by the Lokata, and which was the subject matter of the challenge in this writ petition. 9. CTV Jamil Learned Counsel for the appellant has submitted that the bar which is envisaged under Section 9 of the Act of 2017 has to be given a strict interpretation, as the objective and scheme of the Act is to have a corruption-free society. It is submitted on behalf of the appellant, firstly, that the bar would be applicable only in a complaint involving a grievance. And in the instance case, the complaint was not involving a grievance per se, but an allegation of overstay by the three petitioners. It is submitted that the position would be even clearer by reading of the matter in second schedule, serial number D of the second schedule as extracted above. The learned counsel accordingly submits that in view of such clear purpose and objective of the act of such, the view taken by the learned single judge may not be correct view, and accordingly the judgment and order is to be interfered with. The learned single judge has allowed the writ petition against that defect flourishing. Now, para 16. The bar of investigation is only a measure not to get a locata flooded with complaint involving grievance pertaining to those matters mentioned in second schedule. A bare reading of the matter under serial number D of the second schedule, read with Section 9 of the Act of 2017, would show that those matters are necessarily pertaining to the party involving which anything to do with this appointment, removal, pay, superannuation, etc. In this case, regularization. It is only when a party who is aggrieved by any of the action pertaining to the matter mentioned above that such a complaint is part under Section 9. The said bar, however, cannot be extended to an allegation by a third party, which is the case here in your lordship, a complaint by a third party, the respondent number 4. And in the instance case, it is not in dispute that the allegation is by a third party and not by the writ petitioners pertaining to do with their service condition. 17. Prima facie, your opinion that the order dated 7/20, whereby the submission of writ petitioner to invoke Section 9 of the Act of 27 was rejected, does not suffer from any legal infirmity. So the order passed by the lower court must have held your worship. Now, next is Writ Appeal 41 of 2025. This is a judgment order dated 25/3/2026. Only two paragraphs, 11 paragraph, 21 and 22. May I read out 21 and 22? In fact, your lordship, not only the Nagaland local attack, even some other local also similar provision.
And the acts are broadly similar.
Yes, broadly similar. Yeah. This court now 21. This court now finds it relevant to take note of Section 9 of the Act of 2017, which refers to matter which the locata shall not investigate. 9.1. Section 9.1 starts with the word except as hereinafter provided and proceed with what the locata or the opalocata shall not investigate. It stipulates in clause A and B of subsection 1 of Section 9 what the locata or opalocata shall not investigate. Clause A of Section 9.1 is of relevance in as much as it is the case of the petitioner that the locata cannot investigate in respect of matter if such action relates to matters specified in second schedule. We have taken note of the second schedule, which specifically relates to Section 9.1a of the Act of 2017. It includes various types of action which the locata cannot investigate, and in terms with clause D of the second schedule, action taken in respect of appointment, removal, pay, discipline, superannuation, or any other matters relating to condition of service of public servants cannot be taken up for investigation.
These service matters cannot be taken up for investigation.
When the complaint relates to complaint involving grievance, but not allegation. However, next, at clause T itself, it is mentioned that claim of pension, gratuity, or provident from which arises or determined removal or termination of service, and such an action involving allegation of corruption is not barred under the provision of Section 35 of the Act. Take into account the importance of clause T to the present dispute. We reproduce this. That has been reproduced. From the above quoted clause, it is apparently clear that when it relates to allegation of corruption in respect of appointment, the bar contained in section 9(1)(a) of the Act of 2017 will not apply. That here, Your Lordship, the matter relates to appointment, but here the allegation is that the petitioner has fabricated or forged
Fabrication,
regulation.
but not corruption. Anyway,
Yes.
fabrication of
Yes,
documents
yes,
for regularization.
yes.
That is the crash of that
Forgery.
forgery. Okay.
So, Lordship, in the present case, as the complaint is a complaint involving allegation against the petitioner by a third party, that is respondent number 4, Your Lordship, alleging that she has forged her regularization order. The law court did not commit any illegality. In fact, the investigation was conducted within the purview of the jurisdiction and power of the law court. Now, Your Lordship, irrespective of the issue raised in the writ petition, Your Lordship, in my respectful submission, for the petitioner to invoke the writ jurisdiction, he must approach this honorable court with clean hand, Your Lordship.
Yes.
But in my respectful submission, the petitioner is before this honorable court, not only by suppressing material facts, Your Lordship, but also by misrepresenting material facts. There's a separation of material facts, and there's also misrepresentation of material facts, Your Lordship. So before I go into the merit of the case, Your Lordship, I may be permitted to make just a small preliminary of submission, Your Lordship, on separation of material facts, Your Lordship. May I take Your Lordship to paragraph 5 of the writ petition? The learned counsel for the petitioner has read the paragraph, Your Lordship. Paragraph 5, writ petition, page 6.
Okay.
That the petitioner, as well as the respondent number 4, participated in the selection process. They were both called for the oral interview. Thereafter, by order number such and such, dated such and such, the respondent number 4 was appointed as an APO on regular basis. This is Assistant Project Officer, Your Worship. In the case of the petitioner, for reason best known to the state respondents, Your Worship may kindly take. In the case of the petitioner, for reason best known to the state respondents, 2 orders of even number and that were issued with such and such. By 1 order dated 1/3/86, her service was regularized, and by order dated 1/3/86, her appointment was extended till further order. Now, may I take Your Lordship to the impugn order, page 150. Page 1. This is the order 8/10/2020. Your Lordship has got it. May I take the relevant page, page 158. May I read on? The IU has called Srimati such and such, this is the petitioner, to give her an opportunity to produce evidence and any other documents to prove that her service was regularized after successfully passing an interview. Her statement before the IO, and Your Lordship, the fact that she has appeared before the IO is not being denied, is I am to state that I was selected for interview serial number 16 where my name appeared as such and such. I am also to state that I was not given any appointment order after interview as my name did not figure in the list of candidates listed out in the selection board to be appointed by the LPO. Now, what is the statement made in paragraph 5? In the case of the petitioner, for reason best known to the state respondents. But here by her own statement, she has not been selected for appointment as APO by the selection board, Your Lordship.
Mhm.
Now, these facts have been suppressed, Your Lordship. Now, not only, Your Lordship, petitioner has suppressed material facts, Your Lordship, she has also misrepresented material facts, Your Lordship.
Okay.
May I take Your Lordship through misrepresentation, para 6. That Lordship has got it?
Yes.
That after the issuance of the said respective appointment order, the petitioner and the respondents as colleague began working as APO in the office of the SRD at Kohima. That is to say, both of them began serving in the same office. The fact that they were both appointed on regular basis through the selection process was well known to each of them and to the employees of the SRDA. The existence of two orders.
Wait, please, Your Lordship, my matter is going to be called up. May I be excused for a moment? My juniors will be here.
No.
I'll come back to reply.
May I continue?
Yes.
The existence of the two orders in the case of the petitioner was known to all in the office, including the respondent number 4. The regularization offers was never questioned. Subsequently, by order number such and such, the petitioner was promoted to district project officer. Now, Your Lordship. When by our own admission, she was now selected by the selection board for appointment to the post of assistant project officer, Your Lordship. The statement of the petitioner in the writ petition, Your Lordship, that both herself and the respondent number 4 were appointed on regular basis through a selection process amounts to deliberate misrepresentation of facts. First is separation. And now there's misrepresentation. Now, may I again take Your Lordship to the impugned order, that page 158. Third paragraph, 158. I have read the first para, third para. As regards the two contradictory orders of regularizing her ad hoc service and the other order of extension of her ad hoc service as APO, she stated that I am to state that I was not aware of the regularization order earlier, and therefore it might have been issued retrospective backdated by the competent authority to the date of my extension order as I was selected. Now, when she herself was not aware of the order regularizing her service, the statement of the petitioner that her regularization order that was known to private respondent number 4 and also to all others who is working in the office is also amounts to misrepresentation of material facts, Your Lordship. So, under the given facts and circumstances, Your Lordship, from the statement was made by the petitioner, on the face of it, Your Lordship, separation of material facts and misrepresentation of material facts is writ large, Your Lordship. So, on that ground itself, Your Lordship, as per the what has been held by the Honorable Appeals Court in KD Sharma's case, Your Lordship, which is reported in 2008 to SCC 481. 2008 to SCC.
I'll write down the citation.
2008 12 SCC 481.
Okay.
That is on
Separation of
facts. Relevant paragraph 34, 36, 38, and 39. Lordship has got it.
34, 36.
34, 36, 38, and 39. May I read out? The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hand, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts of or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merit of the claim, Your Lordship. Just and Your Lordship, I'll read only 39. I'll skip
Yes.
13.
The primary
The
object.
primary object, as highlighted in Kensington income tax such and such, is kept in mind. An applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hand. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but states them in a distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule and refuse to proceed further with the examination of the case on merit. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court for abusing the process of court. Next, 2010, 8 SCC, 383, para 34. Thank you. Para 34. Married on. An act of fraud on court is always viewed seriously. A collusion or conspiracy with a view to deprive the right of the others in relation to a property would render the transaction void ab initio. Fraud and deceptions are synonymous. Although in a given case, a deception may not amount to fraud, fraud is anathema to all equitable principle, and any affair tainted with fraud cannot be perpetuated or saved by the application of equitable doctrine, including res judicata. Fraud is proved when it is shown that a false representation has been made.
Okay.
In this case, Your Lordship, in my respectful submission, there is a false representation made by the petitioner in the pleading, Your Lordship. So, as per the law laid down by Honorable Apex Court, Your Lordship, in my respectful submission, the writ petition is liable to be dismissed without going into the merit of the case, Your Lordship. Now, on merit, Your Lordship. May I take?
Yes. Yeah.
May I take Your Lordship again to the impugn order at page 150?
One
150.
There's a
There's the impugn order. It
starts at 150.
does. Now, order with 150. Lordship has got it?
Yes. 150.
Now, at the end, judgment and order written by such and such, Upalukata. Oh, Your Lordship. Now, though it is styled as order, Your Lordship, in my respectful submission, what does the order says? Whether the order, there is a positive direction or locata has made only recommendation. Now, page 134, 159.
155.
161.
161.
61.
Okay.
In my respectful submission, this is the operative portion. And what is the operative part say? The operative part of the order. In our considered view, upon looking into the facts of the case and on examination of all available record, the ad hoc service of such and such, that is the petitioner, as APU has never been regularized, and her ad hoc service continued to be an ad hoc appointment, and as such, even the promotion to the post of DPO as recorded in the service book is not supported by any documents, and as such, not tenable.
This is a finding.
Only a view has been based on preliminary inquiry.
Okay.
Only a view has been expressed. In fact, Your Worship.
According to you, it's a view.
Yes,
Of views.
only a view.
So, yeah.
And
That's the point of.
and may I take Your Worship, please, section 15.
Maybe.
The interim report based on preliminary inquiry. Lordship has got it.
This was section.
15, interim recommendation, 15 and 16. One is recommendation, one is report, interim report. These are preliminary. So 15, Your Lordship. If during the course of preliminary inquiry, like in the present case, or investigation under this act, the locata or upalot is prima facie satisfied. Locata will be can only be prima facie satisfied only if a finding is arrived. Without arriving at any finding, Your Lordship, how can the question of prima facie will come? So I did not trouble Your Lordship by reading the entire order, Your Lordship. The order, the finding arrived, the finding has been arrived, but that is only preliminary. And by that, in fact, Your Lordship, this is a case where Your Lordship, as per the act, look at the ought to have made recommendation instead of expressing views. And by expressing view, no prejudice has been caused to the election. Maybe the nomenclature uses the order instead of views dated such and such or recommendation. Instead of that, order is used. But by the impugn order, only view has been expressed. On the other ground, Your Lordship, can we continue after break, Your Lordship?
So according to you, since no positive direction has been imposed, therefore it does not, even if recommendation ought to have been made, has not been made, only the finding, the prima facie satisfaction has been recorded, it does not prejudice the.
In my respectful submission, view is much more lighter than recommendation.
That's true. Okay. We continue.
No. You brought key of
Yes, let us resume.
Map this lordship. Now, lordship, on non-furnishing copy of the complaint.
That is
On violation of natural justice,
Mm.
not been heard without hearing, not
Yes.
furnishing copy of the
Mm.
complaint. On that, your lordship, may I take your lordship to section 19 of the Act?
Nineteen.
19.
Yeah, it has been refused on the ground of secrecy, but
Yes, every preliminary inquiry or investigation shall be conducted in private. That is on secret. And 12, your lordship. 12 in my respectful submissions will come into play.
section 12.
12.
No.
The lokata or upalokata shall in each case
Principle
before
of natural justice. This is the thing I was thinking.
Yes. Now, in my respectful submission, your lordship, section 12 will be attracted only when regular investigation is done. That is my submission.
Regular investigation.
Regular investigation, not preliminary. In
Not
fact,
preliminary inquiry.
yes, not preliminary. Even your lordship, in the case of Ramarao, your lordship, Honorable Apex Court has held that it is not necessary during preliminary inquiry to issue not even notice to the public servant, your lordship. Now, that is 1996.
Just a minute.
5 SCC 304.
Yes.
1996, 5 SCC 304.
Para was-
This is also Andhra Pradesh local.
Yes.
Para 4 and 5. The Lokata is empowered under the Act to conduct such preliminary verification as
Where are you reading?
Para 4 and 5.
What is contended by? It starts like that.
The Lokata is empowered. I'm sorry, page 1995. 1996, volume 5, SCC 304.
So not this one. For Ramarao, yes.
Yes. This Andhra Pradesh Lokata, your lordship.
Yes, got it.
Married, no?
Hmm.
The Lokata is empowered under the Act to conduct such preliminary verification as it deems fit or proposes to conduct any investigation under the Act to find whether the allegation in the complaint prima facie justify for conducting regular investigation. Subsection 2A of section 10 postulates that every preliminary verification referred to in subsection 1 shall be conducted in more or less same in private, and in particular the identity of the complainant and of the public servant affected by the said preliminary verification shall not be same as in Nagaland Lokata Act, your lordship.
So in this case, it was an inquiry.
Preliminary inquiry. Now, para 5.
But police statement was recorded.
Yes.
Police statement was recorded.
Now, your lordship.
As a-
The Lokata has investigation wing,
Yeah, wing.
lordship. And
It has an in-house investigation.
yes, in the investigation, there are officers who manage the investigation wing, and they are designated either as IO, SI, inspector, not necessarily police in uniform, the local. They have their investigation wing. Para 5. Considered from the operational perspectives of the above provision, it would not be necessary to issue any notice or give opportunity to a public servant as preliminary verification or investigation. Fourth line from there, the object, Worship has got it. The object appears to be that the preliminary investigation or verification is required to be done in confidentially to get prima facie evidence, so that the needed evidence or material may not be got suppressed or destroyed. In this case, Your Lordship, in fact, it was not necessary, but even the IO has called the petitioner, and which is also not, and she has also given statement, Your Lordship. Otherwise, as per this, it is not necessary.
IO has called her as part of the inquiry, not
Yes.
investigation.
The preliminary inquiry. Because Your Lordship may kindly see the impugn order, page 150, page 150. Second paragraph.
Yes, I'm
150, second para, Your Lordship. Second para, page 150, the impugn order.
Yes. Second part. Preliminary inquiry.
Yes, yes. Now,
That means preliminary inquiry was ordered by the earlier.
look at that. Yeah.
Earlier. That's fine.
So, in my respect,
Okay.
in my respectful submission, Your Lordship, as the impugn order has been passed by the local there, in connection with preliminary inquiry, Your Lordship, no interference at this stage is called for by this honorable court. And in support, Your Lordship, I am allowed to place one citation, 1996 for SCC, 1996 for SCC, 406.
Para 5.
Para 5. May I read out?
Yes.
We find it difficult to appreciate how the division bench thought it fit to quash the preliminary inquiry, particularly when the appellant had made it clear by the time the division bench disposed of the appeal that the formal inquiry was yet to be held. Obviously, the purpose of constituting the commission of inquiry was to hold only a preliminary inquiry to ascertain, Your Lordship may kindly take note of it, Your Lordship, to ascertain whether there was some truth in the complaint made against respondent number 1 and whether there was enough material on the basis of which misconduct of respondent 1 could be proved. Now, Your Lordship, then fourth line from the bottom, there was hardly any role for the court to play. Your Lordship has got it at this stage. The learned single judge had already dismissed the writ petition as premature. Now, Your Lordship, may I repeat again? The preliminary inquiry was only to ascertain. And to ascertain, Your Lordship, the meaning of the word ascertain. As per Oxford Dictionary, Your Lordship.
Ascertain.
Ascertain. The meaning of ascertain as
find out.
To find out for certain. A finding must be arrived at, Your Lordship, preliminary inquiry, even whether to make a recommendation without arriving at a finding. Your Lordship. So preliminary inquiry is conducted just to ascertain. So in my respectful submission, Your Lordship, by the impugn order, Your Lordship, as I've taken to Your Lordship to the operative portion of the order, in fact, no positive direction has been passed. Only a view has been expressed based on the finding arrived at during the preliminary inquiry, Your Lordship. And Your Lordship, and by the view so expressed, no constitutional or legal right of the petitioner has been infringed. No, in fact, Your Lordship, the petitioner cannot be said to be aggrieved by the impugn order. And in order to invoke the writ jurisdiction under 226, your lordship, the petitioner must be an aggrieved person, aggrieved by that order, your lordship. Because only a person who is aggrieved or whose right has been adversely affected can invoke the writ jurisdiction under 226, your lordship. And in support, your lordship, may I place before your lordship the case law 2013 for SCC Ayub Khan. 2013 for SCC 46. Para 9 and 10. Para 9 and 10, your lordship.
Yes.
So, person aggrieved. It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority of court that he falls within the category of aggrieved person. Only a person who has suffered or suffer from legal injury can challenge the action, order, etc. in a court of law. Now, that Roman in Italy, after about 10 lines, in fact, Lordship has got it 10 lines from bottom in italic. The existence of such right is the foundation of the exercise of the said jurisdiction by the court.
Yes.
Para 10, a legal right means an entitlement arising such and such. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. In my respectful submission, your lordship, by the impugned order, the only view has been expressed, lordship, by that no prejudice, no constitutional or legal right of the petitioner has been affected. In fact, the petitioner has not suffered any legal injury, your lordship, so as to invoke the writ jurisdiction under 226 of the Constitution, your lordship. So in my respectful submission, the petition is devoid of merit. I have filed my affidavit in opposition, your lordship. Just whatever I've submitted, the para 349 affidavit, para 349, 14, 15, and 21.
49.
3, 4,
14,
9,
15,
14,
and
15, and 21. Just affidavit in
21.
opposition. Yes.
Okay.
Just to sum up, your lordship, now there is not only separation of material facts, there's also misrepresentation of material facts by the petitioner. So in my respectful submission, the petitioner is not before this noble court with clean hand. So for separation of material facts on that ground itself, the petition is liable to dismiss. Secondly, your lordship, by the impugned order, the locata has only, based on preliminary inquiry, Lopat has only expressed his views, and by the views expressed, no constitutional or legal right of the petitioner has been violated. So this petition under 226 is not mentionable, your lordship. Now, and so far as the none on question of violation of natural justice is not concerned, your lordship, as per the law laid down by the Honorable Appeals Court, and the stage of preliminary inquiry, it is even not necessary to issue notice to the petitioner, your lordship. So just because non-furnishing copy of complaint to the petitioner, that should not vitiate the impugned order, your lordship, passed by the law court. So your lordship, in my respectful submission, there is no merit. The petition is liable to be dismissed. I am obliged by resolution.
Keep this. Madam, you would be.
Please, Lordship. Lordship, I'm for respondent 1, 2, 3, and 6. Lordship, here on the point of maintainability, your lordship, I endorse the submission of by learned insult for respondent number 5 on ground of suppression and misrepresentation. Now, as far as the present repetition is concerned, your lordship, the principal challenge is against.
Just a minute, ma'am. 1, 2, 3.
1, 2, 3, and 6.
1, 2, 3, 6.
Lordship, here,
Right.
the
Yes, please.
principal challenge in this repetition
Yes.
is against the order of the Lokayutta.
Look,
So though the state has been arrayed as the main party, we are just a formal party.
Okay.
Yes, Your Lordship. So and then the stand of the state has been placed on record by way of affidavit. And I'm relying at paragraph 5, 6, and 9 of my affidavit in opposition. Paragraph 5, 6, and 9 of my affidavit in opposition.
Okay.
So, Your Lordship, no further submission
Okay.
unless Your Lordship would require
Yes.
any clarification. Your Lordship, and just a clarification to the submission made by the petitioner. Petitioner has been submitting that the disciplinary proceeding
Was dropped.
will cease on the ground that he has been released on service. Now, the state is following CCS pension rules and CCS rules. And in that rule, it says that it will continue as if the petitioner
Was in
is,
service.
yes. So on that, Your Lordship, they kindly allow me.
Perhaps. And as you've heard, Mr. Jamir, and also for the benefit of the learned counsel to the petitioner, one of the main contentions of the learned Mr. Jamir for the Lok Ayukta is that though a view has been he has labeled it as a view has been expressed, but no recommendation has not been made, but no positive direction has been made, which is not permissible. Positive direction judgment is also there, but since no positive direction has been issued, though recommendation has not been made, therefore the order is not bad.
Yes.
That is one of the main.
That is the ground. That is essentially the ground that he's making.
Okay, madam. So this is CCS rules.
Yes.
If it was pending, then it would be continued as if he had continued.
Yes. Even if he is released from service. So that's the point I want to clarify.
This is the latest rule, no? CCS.
Yes.
Rule 9. 2 is this. I remember now. I know this is.
But that's all, Your Lordship.
After some, take some time. 15 minutes.
Please, Lord. My Lord, I am for respondent number 4. There.
Who's the respondent number 4?
4.
Okay.
Yes, ma'am. My Lord.
Private respondent.
Yes, private respondent 4. Short facts only. I'll be able to cover within 5 to 10 minutes.
No.
My Lord, in this case.
You filed an affidavit also?
Yes, we have filed.
Please carry on.
Yes. My Lord, the present petitioner, as well as the private respondent number 4. Initially, we were appointed, the petitioner was appointed on 28/11/1984 on ad hoc basis as APO, Rural Development. APO, Assistant Project Officer. Then my appointment, President of 4, was also issued on 20/07/1984 on ad hoc as APO under the same Rural Development, same department on ad hoc. Now thereafter, on 16/8/1985, the post of APOs, 6 APOs, 1 post of investigator, 1 assistant post were advertised, including the post held by petitioner as well as private respondent, because these were ad hoc appointments. So, in response to advertisement, the petitioner as well as private respondent, all of us participated in the selection process, 1985. Then result came out in 1986. Then petitioner was declared unsuccessful for the post of APO. Yes. unsuccessful. Whereas respondent one was successful against the post of APO.
Okay.
Now, after that, after the selection process was over, government decided to terminate all the services of ad hoc appointees in the department.
After the regular selection.
After the regular selection. Then after that, I was given appointment, office regular appointment.
Okay.
Then in respect of petitioner, I came to know that though she failed in the regular selection process, her ad hoc service was extended by an order dated 1/3/1986.
She was not terminated according to you?
According to the
Your
report.
submissions?
No.
The petitioner, you said all the ad hoc appointees were
Yeah,
terminated.
there was decision.
Terminated.
But in her case, instead of termination,
She was
extension was given on 1/3/1986 as APO veterinary. That is important, my veterinary. APO veterinary. So therefore, throughout the service career, I was under the impression that she was on extension all the time. All the time. Since 1986. And in the post of APO veterinary. Then in 2018, the petitioner make a representation to the Commission Secretary Department regarding seniority between me and petitioner. That time petitioner. The representations of the petitioner is dated 31/7/2018. Only through her representation, I came to know that she was having another regularization order of the same date, 1/03/1986, on which date her ad hoc appointment was extended. Same date, same government or same official, by the same official. Regularization. Same date by the same official against two postmen. This is what we have said. This is a clear case of forgery. One is APO veterinary as per the extension order. I have annexed in my FA. Another is regularization orders carrying the same date as APO general, with the general. So therefore, how can the same official issue two same appointment order against two posts? APO veterinary, APO general. There are two different branches. Though
the regularization order was of APO, the extension was of APO veterinary.
But regularization APO general, with the general.
General.
Yes. So therefore, become very curious. So surprised to see. And this was hidden by her all the throughout. Extension was always revealed. So we thought, I was in the impression that it was all the time under extension. Then this was suppressed. The regulation order as APO with the general was suppressed. I came to know only when she submitted a representation in 2018 regarding seniority between me and the petitioner. So thereafter, now therefore delay, question of delay, section 9 of our Law Kayata Act talk about delay. If there is a delay of filing any complaint regarding allegation after 5 years, I am well with it. I came to know that the thing only in 18 through her representation. So I have filed complaint in 2019, 17/04/2019 against petitioner to the department.
the 1 year limitation applies to
Grievances. Grievances. I came to know only through her representation. Now, Lordship, I'll just draw Lordship's attention only to that document. How I came to
But
know.
in case of complaint, that absolute limit of 5 years will apply. Right.
That will come only against me, start from 18 only. Because the day I came to know, may Lordship's attention to my affidavit, page 20, just
I'll come
to show Lordship. How I came to know.
Will be here, affidavit. No.
Affidavit filed by private respondents.
Yes. 1/4.
4. The last page of my NHL.
No.
Just to show it.
It's a repetition.
How I came to know and what I have explained. What is my grievance?
Can you check this? Affidavit in reply. This is the affidavit in reply to
Respondent number 4.
4. So you want the affidavit in opposition of respondent number 4. Okay.
Last page, my. How I have brought this to the notice of the government.
Last page, running
Last
page.
27.
27?
Yes, last page.
No, not this one. Yeah, this is the one.
Last page. My lord, may I read it, my lord?
Yes.
Yes.
Last 27.
Yes. To the Commissioner and Secretary to Government of Nagaland, Rural Development Department, through property subject prayer for seeking clarification and authenticity of the regulation order of Srimati Thondena Mujui, Project Director, DRDS, sir. With reference to the subject cited above, I have the honor to state that the supporting document of the service regulation order submitted by Srimati Thongdena Mujui attached in her representation dated 31/7/18 as Annexure D, copy enclosed, may kindly be re-examined to confirm the authenticity of the case to ascertain as to whether her service has actually been regularized, and if so, through which means she has been regularized. The office copy of her extension order contradicts with her regulation order, as both the orders have been issued on the same day, that is 01/03/86, by the same authority within bracket Entali Jamir, placing her in the same place of posting as the SRDA Kohima for 2 different posts. That's why I'm saying, man, for 2 different posts. One as APO veterinary and the other as APO general. The said documents in question appear to be fabricated and malicious, and the signature of the authority means to be forged. Once, Lordship knows very well, once forgery is proof, no issue is necessary to be discussed in any case. This matter may kindly be carefully examined and disciplinary action initiated against the erring official if found guilty. Therefore, in view of the above, I earnestly request your esteemed authority to thoroughly examine and take appropriate necessary action deemed fit at an early date. Signed by the private respondent. So only through this I came to know. So there's no question of delay as in terms of rule, in terms of section 9. Now, this matter was, my lord, thereafter. So this was brought to the notice of the government. Then government referred the matter to PNR for its opinion. PNR. Then thereafter, PNR has passed necessary observation
directing the department, concerned department, to do two things. Directed department to go for necessary suspension and also register a criminal case. PNR's opinion. Now,
Is the order there? This order is here? In the affidavit?
my lord, that is in the
Here.
yes.
Okay, no problem.
It is reflected in the impugn order.
In my
It is reflected in the impugn order.
Order.
this is ours, na?
That is small. Okay, okay.
Yes. So now, again, Lordship, I'll just show the facts. I'll show her appointment, her extension order as well as regulation order, bearing same date against two posts by the same authority. Just short facts. Page. My lord, page 23. Lordship, page 23, original copy, but next page I have typed. Page 24 is the typo.
No.
Yes.
It's also a man.
Yes. So now this is dated. This is APO second part of the order. In the interest of service, the officer is posted as Kohima as APO veterinary by the same officer and Tali Jamir, dated 1/3/86. Then next page. Page 25 is the original, but type is page 26. Same date, 1st March 1986. Then second paragraph. In the interest of public service, the office is posted to the SRDA Kohima as APO General. So, my lord, my contention is, if this is not forgery, what is forgery? If it is not suppressions of facts, what is suppressions of facts? If it is not misrepresentation, what is misrepresentation?
No.
Lordship is aware now. After accumulating all these facts, the matter was referred to Lokayuta. As my learned friend who represents Lokayuta has
After the opinion of PNR.
yes. After that, then it has gone to Lokayuta. Then Lokayuta has conducted preliminary inquiry, as we have seen from the order of the Lokayuta, last part of the order. Then Lokayuta has just given its finding, view, expressed its view, as my learned friend has already who represents Lokayuta has expressed.
But actually, that's okay. But Lokayuta statutorily is also required to give a recommendation.
Correct.
Following up.
Recommendation and finding should be given.
Based on that,
without
determination.
My lord, without finding,
Exactly.
of the any investigation, how the committee will come to a dictation.
Prima facie, that will be necessary.
Yes.
It will be necessary.
Now, my lord, all these facts today, I have filed affidavit. My lord, I finished my relevant paragraph, page 2, para 2, page 2, para 2, para 2, page 2, para 2, sub para 1 to 9. I have already projected all these facts in my affidavit reply. So these are the facts I have highlighted so that it will be convenient. My lord, now, through this affidavit, I have brought the above facts to the notice of this High Court as well, apart from Lokayuta, the inquiry report view expressed by Lokayuta. Today, through this affidavit, I have brought these facts, the above facts before this Honorable Court. So, should this Honorable Court take judicial notice on all these crimes, illegalities, if committed by any official? I'm not blaming anybody. If there is any forgery, if fraud is to establish the fraud, this court is not barred. This court has ample jurisdiction to give its own judgment even. Forget about that. Assuming that if Lokayuta order or inquiry report or review is illegal, assuming, I'm not admitting that. Even then, after going through all these facts, is it not a fit case to order that competent authorities should take necessary action so that this kind of illegal act will not be repeated by those officials who are in the office today? Unless this is checked through judicial order, my lord, the citizens look up to the temple of justice to see that crime is stopped, to see that illegal things are stopped. If the petitioner can come up clean after investigation, fine. But my only prayer, Lordship, have seen my application now. Only prayer that please verify, investigate. That much only I'm saying in my. So therefore, in my respectful submission, my lord, the views expressed by the Lokayota is absolutely reasonable. And apart from that, in my respectful submission, even this court is not barred to pass any law to do justice to everybody, not only me, to everybody. What is wrong? What is difficulty that this court direct department to even go for some investigation so that the correct fact will be established, and if anyone is found to be guilty, law will follow suit. This is my short submission, Manjot.
Respondents are complete, right?
Yes.
Reply. Okay.
Short points of reply, my lord. My lord, the submissions of the Lokaयुcta, the stand of the Lokaयुcta, the stand of the state, and the stand of the private respondent. It proves, if I may humbly submit, my lord, it proved just one fact. And that fact is there is a collusion between all the answering respondents. And why do I say that, my lord? Why do I say that, my lord? The state was a supporter of the private respondent number 4 when she decided to change her entry into service from 84 to 86. The state allowed her illegal request to change her date of entry in service from 1984 to 1986. Everything emanates from that singular fact, my lord. Everything emanates from that singular fact. And unfortunately, the Lokaयुcta has also become a party to that illegal act of collusion between the respondents.
Would you like to make any submission regarding that, which he has replied that this fact is not disputed?
Not disputed. Not disputed.
It was changed.
Yes, it was changed. It was not disputed, man.
Okay.
And because of this challenge by the petitioner, this animus towards her is continuing even till date. And one point of note, Your Lordship, all she is saying, it is just a view. It is just a view. But my lord, the hard fact of the matter is this view has resulted in positive actions. And how positive actions, Your Lordship? Though I have retired with effect from 30/11/2019, I am not being paid any pension. Why? Because the Lokaयुcta has held. Kindly come to the impugn order again at page 150.
Because of this,
Yes.
getting the pension.
What does it say? I only agree with one submission made by my learned friend, page 150. One submission made by my learned friend that regardless of the nomenclature, go to the contents. The contents say what? Judgment and order. And at page 158,
Yes.
at the bottom of the page, Lordship may kindly see. In view of the above facts on record, we hold. This is not a finding, Your Lordship. This is a judicial order. The complaint has been decided. We hold that the order dated 1/3/86, regularizing the service of on successfully qualifying is an illegal order and not tenable in law. This is not a finding order, Your Lordship. This is a judicial order. A judicial order by a body which is coram non judice is non-est in the eye of law, Your Lordship. Your Lordship is well aware of that. How could the Lok Ayukta have come to this finding. This is a judicial order, my lord. The Lok Ayukta has decided the complaint filed by the respondent number 4.
A full judicial order, in my humble opinion, would have been that holding it to be illegal and then going, what the court would have done, suppose.
Yes, ma'am.
You know, that if the point, this is the finding of the court.
Yes, yes.
The next step would be
Terminated from service. Terminated from service. So that is what I was saying, Your Lordship.
But obviously, the Lok Ayukta could not.
Yes, could not have come to this
But
could not have come to this
the
decision.
Land Council on the other side, this is a view. According to this is a judicial order.
No, this is we hold that the service is illegal.
Strong view.
Yes, it is no more a finding, Your Lordship. It is a decision of the Lok Ayukta. If the Lok Ayukta can only give findings and make recommendations on the basis of that finding, it cannot hold a finding as illegal. So, making this finding into something which is illegal, holding it to be illegal, that is totally beyond the jurisdiction of the Lok Ayukta. And not only that, Your Lordship, not only that, the further point of note, my learned friend has been relying on all these statements which are attributed to the IO of the case and saying that this is a misrepresentation of facts, suppression of facts. Are we a police state, Your Lordship? Can this honorable court countenance such a submission which is being made both by the Lok Ayukta as well as the private respondent? Are we a police state? This is effectively the CD of the IO of the case. Can the Lok Ayukta, acting as a quasi-judicial authority, rely on the CD of the IO of the case and come to findings, my lord? And can these so-called findings of the IO of the case be classed as suppression of facts, misrepresentation of facts? Not at all, my lord. In the first instance, I am saying that all along I was under the impression that, and all along I still hold that I have been appointed regularly beginning from 1984 after the selection process in 1986. But after 86, kindly note, Your Lordship, I have been stressing this point again and again. After 1997, when the employees of the SRDA were brought into the state service and block, all temporary employees, permanent employees, casual employees became employees of the state. So what happened prior to 1987, no matter what kind of entry the employees had in the mode of entry to service, they became regular employees of the state with effect from 1987. Now, Your Lordship may have a question as to whether, if they were employees in 1997, how seniority would relate back to the date of initial appointment. Earlier, there was this policy, Your Lordship, of allowing seniority with effect from dates of initial entry in undertakings.
Yes.
That is gone now. That is gone now. That is gone now. Now, I'm very surprised that the state, Your Lordship, state saying that we follow the pension service rules and disciplinary proceedings can continue after an absolutely misleading statement. We have our own disciplinary and appeal rules. And our own disciplinary and appeal rules is the Nagaland Disciplinary Appeal Rule 1967, something we have had since 1967.
Assam is 1964.
Yeah,
Nagaland
yes.
67. Which one will prevail? Ma'am?
This will prevail, Your Lordship. This is what governs our disciplinary proceedings. 1967.
Discipline and appeal.
Yes. What my learned friend, the state is relying upon is general rules of the central government. State may adopt or not adopt. But this is a special rule with regard to the state of Nagaland. And in this act, there is no provision for the continuance of proceedings after retirement. And then not only that, Your Lordship, not only that, I'm very surprised as to how the Lok Ayukta and even the state respondents can continue to press the case against the petitioner. Unfortunately, Section 10, Your Lordship, Section 10. Section 10, once more, Your Lordship. Section 10 of the Act of 2017. Has Your Lordship got it? So, provision relating to complaints, subsection 2. Every complaint shall be made in such form and in such manner and shall be accompanied by such affidavit as may be prescribed. Where is the complaint even till today, my lord? And the representation which my learned friend is saying where I am claiming seniority over the respondent number 4. Totally misleading statement. That is misrepresentation. That is actually misrepresentation. At page 12 of the affidavit in opposition filed by respondent number 4.
Take up the affidavit.
Yes, Your Lordship. Yes. The affidavit of the respondent number 4.
Yes. So keep separating. Just now I've taken up, not this one. This one. No, not this one. The judgment separately, not separately.
Yes.
Page
12. I did not claim seniority over her. I brought out the fact that she was illegally claiming to be appointed from 1386. Page 12. This is the affidavit which the respondent number 4 says that the representation by which I am claiming seniority over her. May I read the contents, my lord? I beg to refer to the subject cited above and to state the following few lines before you for favor of your early recovery action, please. That, sir, as per seniority list on 11015, Shrimati Asangla.
Just a minute. So,
Page 12.
You're reading the affidavit of respondent
number 4.
The one.
Oh, I'll reply, my lord. I'll reply.
So you're
my reply, ma'am. My apologies, ma'am.
no issue.
My reply.
This is
Yes, yes. I am the one who is placing all this on record, my lord.
Affidavit reply, page 12.
Page 12. To counter all the false statements being made in the affidavit in opposition filed by both respondent number 4 as well as the state respondents. In the reply, your lordship may kindly note, in the affidavit in opposition filed by the respondent number 4, a false statement has been made saying that I am claiming seniority over her. This is the actual affidavit, the actual representation. I beg to refer to the subject cited above and to state the following few lines before you for favor of your early recovery action, please. That, sir, as per seniority list on 110-2015, Shrimati Asangla, Project Director, seniority position shown as serial number 7, whose first appointment as APO in SDRDA on 21/7/84 and in a tentative seniority list as on 31/3/18, her seniority starts at serial number 3, and whereas the first appointment shown as on 21/7/84, number 2, the ad hoc services of TODO, Shrimati Asangla Timjun, and others were extended up to 21/28/1986 by SARD order dated Annexure C. My service has been regularized with effect from 1/3/86 by order dated 1/3/85, and my seniority as on 1/10/25 is at serial number 8, and my first appointment as APO indicated as 29/11/84. Now, it is regretted to point out that as per relevant sources, Shrimati Asangla is claiming that she has been appointed first as APO in 86. Can you look at that, my lord? Is appointed in 86, but not as 21/7/84. So now she actually wanted to become junior to me to claim length of service. She being senior to me, length of service. Look at that, my lord. I am acknowledging that she's senior. She being senior to me in length of service, as per merit, she is above me when departmental had conducted open examination and for all ad hoc deputationists and others. As per above, all along, her first year of entry, 21/7/84, has been treated as authenticate documents, and only now she is claiming she joined service in 1986. I am not claiming seniority. A false statement was made in the affidavit that I submitted a representation and claimed seniority over her. That is there in the affidavit. Your lordship may go through the affidavit of the respondent number 4. This is the representation which I submitted. I told the state respondents that she was appointed in 1984. She could not claim to have been appointed in the year 1986. Notwithstanding my representation, they gave her date of entry into service with effect in 1986, because of which I filed a writ petition, which went in writ appeal and which is now pending in the Supreme Court. This is the representation, my lord. This is the representation. So suppression of facts, misrepresentation of facts. I am not the guilty party here, my lord. The respondents collectively, all 3 of them, are guilty of misrepresentation and suppression of facts.
They've ganged up against you, huh? They've ganged up.
Yes.
All of them.
They've ganged up on me. And I, as a pro-private citizen, I am powerless against them. They hold the entire might of the state in their fist, my lord. So this is the case. This is the case, my lord.
I just bother you one thing. Can you just throw some light, on the? I want to refresh that, point again on that changed from 84 to 86 with regard to respondent number 4.
Yes.
Or
So 84.
you can also
Yes.
reply
The 84 ad hoc appointment.
appointment.
In the year 1985 selection process.
86
selection process. She was regularized with effect from that particular date, 1/3/86. She filed a writ petition saying that in her first writ petition, she wanted to claim seniority. So she said she was appointed on regular basis in the year 1984. That was the first claim. That first writ petition was dismissed. Subsequently, she submitted a representation saying that in the selection process, that was her first appointment. So her date of entry into service should be taken as 86. 86. So now she revised her claim from 84 to 86 so as to get the benefit of length of service. She would have gained 2 more years of service.
From 86, regular.
Yes. Regular
But length of service,
yes, ma'am.
according to you, would be from the date of initial appointment.
Yes.
Ad hoc.
Yes. Because according to our rules,
Yeah.
Your Lordship, ad hoc service is counted.
1986.
Yes. For the purposes of pension, etc.
Yes.
Yes. For the purposes of pension, etc., ad hoc service is also counted as towards the length of service. Then, Your Lordship may kindly see Section 12. Again, in the rules, in the Act of 2017. The Local Act. Section 12. Procedure in respect of investigation. The Lok Ayukta or Upalok Ayukta shall in each case before it decide the procedure to be followed for making the inquiry and in so doing ensure that the principles of natural justice are satisfied. Now, at the cost of repetition, if I may, my lord, I have never been summoned before the Lok Ayukta or the
Saying that it's a preliminary inquiry.
Yes, my lord.
And also mentioned like that in the order.
Yes, my lord. Now, my
So
lord.
in preliminary inquiry, it is that secrecy aspect.
Yes, my lord.
Regard to be maintained.
Yes, my lord.
But with regard to investigation, this is conspicuously missing with regard to preliminary inquiry.
Yes, my lord. No, the point is this, my lord. The preliminary inquiry is taken note of by the Lok Ayukta. That is a different proceeding now again, Your Lordship.
Okay.
The preliminary proceeding doesn't end there. The preliminary inquiry is taken note of by the Lok Ayukta. And the Lok Ayukta is required to appreciate the report and make its report to the government. So that part is distinct again, my lord. That part is distinct. Can you imagine a process, my lord, where the Lok Ayukta, acting as a quasi-judicial body, passes orders without hearing the person against whom a complaint has been filed? And Your Lordship, the Supreme Court is very clear. If natural justice is not specifically mentioned, it must be read into the provisions.
Yeah, the court can, the question of on the statute, in the language of these provisions, it is conspicuously missing.
Yes, my lord.
In 11.
Yes, my lord.
And present in 12.
Yes, my lord.
If it is read into it by the court.
Yes, my lord.
Another matter.
Yes, my lord. No, and in the circumstances, my lord, why it becomes more relevant is the Lok Ayukta has taken a one-sided report, preliminary inquiry report, and acted against the petitioner. A one-sided inquiry report in the case of an investigation, Your Lordship. In the case of an investigation, actually, in the case of an investigation, because the IO was inquiring into an allegation, Your Lordship. If you go back to the definition, Your Lordship, go back to the definition.
It was an inquiry. It was not an investigation at all, according to.
But the facts speak, my lord. The facts speak. The IO recorded a statement. It was not an inquiry before an inquiry officer.
What is the procedure of a preliminary inquiry?
Yes.
Can the in-house police
That's the point.
for a preliminary inquiry as well?
Yes, my lord.
That aspect has to.
Yes, my lord. So therefore, we come back to what is a complaint under Section 2F, my lord. Section 2F says complaint means a complaint made in such form as may be prescribed. Where is the form prescribed? Where is the complaint even today, my lord? Alleging that a public servant has committed an offence punishable under the Prevention of Corruption Act 1988. Where is this? Where is this complaint, my lord?
Affidavit was not there. Affidavit was there.
No, nothing. We don't know. I don't know.
So you have not seen it,
I have not seen it. I don't know, my lord.
except that it's.
I have not seen it. I don't know. And if the letter which at page 27 of their affidavit, at page 27, which my learned friend was at pains to refer to, your lordship, at page 27. Where is the allegation here, my lord? There is just an allegation that the document is forged. But where is the allegation that I have committed offence under the PC Act? Where is the affidavit which is supposed to support this application? I don't know if this is the complaint or not, but this is what has been annexed. This is what has been annexed. And then, lastly, my lord, I will conclude my submissions. I will conclude my submissions. At page 161 of my writ petition, this is the last page of the impugned judgment and order, my lord. It is not report, impugned judgment and order.
Page 160.
161. Regardless of what my learned friends on the other side may say, the law collector has passed a judgment and order and decided the case. And this is apparent from page 161. May I read, my lord? Page 161. Apart from 158, where they hold that my appointment is illegal. 161. In our considered view, after looking into the facts of the case and on examination of all available records, the ad hoc service of Shri T. Muzui has never been regularized, and her service continued to be on ad hoc appointment, and as such, even the promotion to the post of DPO as recorded in the service book is not supported by any document and as such not tenable. This disposes the case. Certified copy of this order, not a report, my lord. Certified true copy. Where is the necessity of giving a certified true copy of a report which is submitted to the government? Certified copy of this order and to the authorities there. Can there be any doubt, my lord? Can there be any doubt that this is not a judgment and order? And this is not the local actor sitting as a court. And this goes much beyond a preliminary report and findings and recommendations thereon. With that, my lord, may I conclude? Much obliged for a very patient hearing, my lord.
No, it's my duty.
Just clarification to the rejoinder, your lordship, here. Then we have a Nagaland discipline and appeals rule, but then there is no specific provision under that rule. So the general rule will apply here. Even the pension rules, we are following the CCS pensions rule. So now the problem comes here that the petitioner could not get his pension. Why? Disciplinary proceedings could not be concluded. After that only it will be settled. Your lordship,
Disciplinary proceedings, which was initiated against her.
yes.
That is if it is not dropped, it is not dropped.
It's not dropped. It's not dropped.
But anyway,
So there is a
any
procedure.
disciplinary proceeding,
Yes,
I'm
yes.
sure you'd agree, we all agree.
Yes,
that
yes.
Any disciplinary proceeding, since it causes some prejudice, has to be completed.
Yes,
Taken
yes.
to its logical conclusion,
That's
this way
true.
or that way.
Right, right. So that's it. That's my the clarification I want.
There's just one more clarification then, your lordship. Then we have again Nagaland Retirement from Public Services Employment Act. That prescribes 35 years and 60 years.
Here's a notification regarding the applicability of the CCS pensions.
Give me a, you have a question.
These gray areas need to be addressed. So that we don't have to look for the central rules.
Yes, yes.
You know, whatever it is, Assam or 1967, these are all, approximate years.
My lord.
So all these gray areas need to be addressed. Anyway, it has important issues involved in this matters, in this writ petition. So I'll go
Your
through it.
lordship can even go through the notification of this memorandum.
I'll go through
Yes.
it. I'll go through it completely.
But the fact of the matter, my lord, is that the pension rules do not concern discipline and appeal. Just general rules.
Yes.
My lord, in my last page 27, regarding the complaint,
Which we have seen.
yeah, that is not before Lok Ayutta. My land
That was to
friend,
the departmental.
I don't know.
Departmental authority.
Every department, I don't need any affidavit to be sworn here. That's all. Yeah. That is different complaint before Lok Ayutta. That much.
So even today, Your Lordship, states as well as the private respondent have not even produced a complaint before the sovereign court.
Just right. Counsel for the petition. So I examine for respondent number 5. And Madam for 1, 2, 3, and 6. Respondent number 4. So for private respondent. Arguments the learned and the arguments addressed by the respective learned counsel. Arguments completed. Judgment is reserved.
Why?
Much obliged.
Can we staple this? Now my homework starts.
Yes.
And since all of them have ganged up against you, you have to see carefully.
We don't envy you that task.
Oh, that's my job. Okay.
Court